Check, mic check. Test. Mic check. 1 2 test. Test. Hello. 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 Check. Check. Mic check. Test. 1 2 3. Check. Hello. 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 Check. 1 2 test. Mic check. Test. Check. 1 2 test. Check. Check. Hello. 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 Check. 1 2 3. Test. Check. Hey. Check. Test. Mic check. 1 2 3. Test. Hello. 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 Check. 1 2 3. Hey. Check.
Hello, 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 hello.
Test. Check. 1 2 3. Check. Test. 1 2 3. Test. Hello. Hello. Check. 1 2 3 4 5.
आप लेके आ रहे हो? हाँ हाँ हाँ, ठीक है, उनको लेके आना। और वो ना ये जहाँ पे मेंबर्स और लेडीज हैं, आप वहीं आ जाते, वो कहीं पे बैठे हुए हैं आर्ट एरिया में। कहाँ पे बैठे हैं सर? हाँ, क्योंकि ना ठीक है, ठीक है, ठीक ठीक। वो फाउंडर लाने बोलो। पर उनके साथ ही रहो ना, जैसे ही ग्राउंड से निकले मुझे बताना, क्योंकि अनाउंसमेंट करनी पड़ेगी ना। सर आ गए हैं, CEO आ गए हैं, तो वो शायद उनको लाउंज में लेके जा रहे हैं, वो क्लियर नहीं है लाउंज में लेके आ रहे हैं डायरेक्टली आ रहे हैं। विमल जी, विमल जी, सर, हेलो, ठीक है सर, ठीक है। अभी चाय कॉफ़ी पी रहे हूँ ना सर, ठीक है, ठीक है।
Ladies and gentlemen, we will commence with the program shortly. I request everyone to kindly be seated and keep your phones on silent mode. Our chief guest of the day is on the way and be soon arriving. Thank you.
जल्दी कर दो, बस आ गए हैं। सर, ठीक है।
Ladies and gentlemen, our chief guest for the occasion, Mr. BVR Subramaniam, CEO Niti Ayog, has arrived. Please join us in welcoming our esteemed guest on the dais. Whole-time member, Insolvency and Bankruptcy Board of India, Dr. Bhushan Kumar Sinha. Joint Secretary, Ministry of Corporate Affairs, Ms. Anita Shah Akela. Joint Secretary, Ministry of Corporate Affairs, Ms. Anita Shah Akela. Dean ISB Professor Madan Pilutala, and Professor ISB Dr. Sanjay Kalapur. A very good morning to one and all present here today, physically as well as online. I welcome you all to the 4th International Research Conference on Insolvency and Bankruptcy, organized jointly by Insolvency and Bankruptcy Board of India and Indian School of Business, Hyderabad. On behalf of IBBI and ISB Hyderabad, I would like to express my profound gratitude to our esteemed guest of the event. We begin today's program with the lighting of the ceremonial lamp. May I request the dignitaries on the dais to kindly light the lamp, please? We welcome Professor Sanjay Kalapur on the dais, please. May I request the dignitaries to kindly light the ceremonial lamp? The Insolvency and Bankruptcy Board of India has had the privilege of organizing 3 international research conferences with IIM Ahmedabad in 2022, IIM Bangalore in 2023, and ISB Hyderabad in 2024. Each was a resounding success, providing a distinguished platform for scholars across disciplines to present cutting-edge research in the insolvency domain. The finest contributions from these conferences were later published in our research publications, enriching the body of knowledge in this critical area. This year, marks the fourth edition of this esteemed series, and we are delighted to have once again received an overwhelming response from the researchers. We remain deeply grateful to the academic and professional community for their dedication and intellectual rigor in advancing insolvency and bankruptcy research. With this, ladies and gentlemen, without further ado, may I call upon Professor Madan Pilutala, Dean ISB, for the welcome address. Welcome, sir.
Good morning, all. A very warm welcome to the distinguished guests on the dais, and a special thanks to our chief guest, Dr. BVR Subramaniam. Thank you very much, sir, for making the time to come and share your thoughts with us. This is the fourth International Research Conference on Insolvency and Bankruptcy, as you heard, the second time in the Indian School of Business. In the four editions of this has very rapidly, it has become the premier national platform in which academics, policymakers, practitioners, all of you come here, gather together to advance dialogue on around insolvency, bankruptcy, credit reforms, and so on. The conference mission, which is to bridge rigorous research with real-world impact, is very much in keeping with the ethos of the Indian School of Business. Dr. Subramaniam was just telling me he had, I think about 6 months ago, in a slightly, I was overawed by the task that he gave us. He came here and he said, "You're writing the Telangana vision document." And he was not broking any disagreement. He said, "You're just going to do this. And the reason you're going to be doing this is because I do believe that the kind of rigor that you will bring from ISB, alongside the dialogue that you'll have with policymakers and practitioners, is going to create a document that is unlike other vision documents that are there in the country." So that is really the ethos of the Indian School of Business, which is that we marry rigorous research with real-world impact. So this conference is very much in keeping with that. The goal for us when ISB was started in 2001 was for us to be the then Prime Minister referred to this as a national gift, So the reason he referred to it as a national gift is he said that a lot of leaders, policymakers, leaders in the corporate world also require rigorous research, rigorous investigation of real-world problems in India. And the Indian School of Business was a welcome addition to the great business schools in the Indian landscape. So we have a few specialized research centers that I just want to briefly touch upon. One of them is the Center for Analytical Finance. So this is again, is an example of the kind of impact that we create. Most recently, they created a tool which was based on some deep academic insight, some deep academic work, which was about an alternative credit scoring scorecard for people who are new to credit, the customers who are new to credit. So this tool, when we think about today, any kind of a tool that we're developing is obviously going to be using machine learning and algorithms and so on. So this particular one does do that. And it uses information from customer application, economic indicators, local demographic factors, and so on, to create what is a robust tool that measures credit. So I just want to stop here. If you have a chance and it stops raining, I welcome you to go and see our newest addition to the infrastructure. We have a new center for exec education, as well as where the research centers are going to be located, not far off from here. So I'd suggest you go and you take a look at that. It's in keeping with the building of world-class infrastructure that the school always wants to do. So we're very proud of this new building that has come up. So please go and take a look there. Of course, the proof of the pudding ultimately is in 4 years, 5 years from now, if the kind of research that we are doing within the school, it's amplified, it goes up to a very different level. With that, I'm going to stop, and I will leave you in the company of this there is very distinguished panel and Dr. Subramaniam. Thank you very much. Welcome again.
Thank you, sir. I now have the privilege to invite Dr. Bhushan Kumar Sinha, whole-time member IBBI, to kindly set the context of this research conference. Welcome, sir.
Respected BVR Subramaniam sir, CEO Niti Aayog and chief guest of the event, Ms. Anita Sahakela, Joint Secretary, Ministry of Corporate Affairs, Professor Madan Pilutla, Dean and Professor ISB, Professor Sanjay Kalapur, Professor ISB, my colleagues from IBBI, distinguished guests, ladies and gentlemen, a very good morning to all of you. It's my privilege and honor to participate in the 4th International It's my privilege and honor to participate and address this August gathering at the 4th International Research Conference on Insolvency and Bankruptcy. I extend my heartfelt gratitude to ISB Hyderabad for organizing this event in collaboration with IBBI. A special mention and thanks to Professor Hariom Manchiraju and his team for making this event possible in the premises of ISB Hyderabad. I have been told, I was just going through this itinerary, and I would say I am supposed to set the context for this conference, which will go for another in the coming 2 days. So I take this opportunity just to give you an idea about the evolution of IBC framework, how it has performed over a period of time, what has been the challenges and difficulties in implementing IBC, and how we have adopted this consultation-driven regulation mechanism in IBBI, and what is the role and research. What has been the contribution of the role and research in the evolution of IBC over a period of time. All of you know that IBC has successfully completed it was a landmark economic reforms by offering a faster and more structured market-driven insolvency process for the structured stress asset for the corporate debtor. It has not only reshaped the overall credit landscape in the country, but it has also played a pivotal role in improving the ease of doing business in the country. It has completed 8 years successfully, and now we are in the 9th year of our implementation. While it was never contemplated as a mechanism, recovery mechanism, nonetheless, I want to share with you, so far we have recovered 4 lakh crore of rupees for the creditor. 4 lakh rupees of the 4 lakh crore rupees recovery for the creditor, especially for the banks who account for 97% of the total recovery, is many of you from the banks, even if you take a credit at a capital adequacy ratio of 10%, that can ultimately amount to a lending of roughly around 40 lakh crore in the economy. And when we have a near-term target of becoming a 5 trillion economy, or for that matter 30 trillion economy by 2047, or Viksit Bharat target, that kind of contribution through the IBC route is definitely going to have a special place in terms of the credit deposit ratio in the country. But from a legal standpoint view, it's not what we have achieved. How it is shaping the behavior of the stakeholders over the period of time, that is equally important. When I talk about the stakeholders' behavior, I'm basically talking about the creditors and the debtors. If you see, the IBC has entirely changed the debtor-creditor relationship in the country since 2018. Many of you are aware that after this IRAC norm prescribed by RBI, income recognition and asset classification norms, our NPA went up to 11.8%, roughly around 12%. Now in 2025, it is at a decadal low of 2%. So this is one of the achievements which can be directly or indirectly attributed to IBC also, that our NPA has gone down. And this is just because this is also because the code has instilled a healthy sense of creditor discipline among the debtors, and it has also a deterrence among the borrowers the fear of losing a business in case the business is going to IBC. The other issue, the other fact which I would like to share is that roughly around 30,000 cases which was filed before NCLT were withdrawn before admission. So, and the amount involved was roughly around 14 lakh crore. And majority of this pertain to MSME. So what I am of the view that IBC has also played a very important role in effectively facilitating MSME recovery. I take this opportunity for IBC also, if we can just do some study on the comparison how IBC have performed vis-a-vis the other platform, that is the Trust platform. It's a platform, electronic platform available to MSME for discounting of their invoice. So if a comparative study will also tell us, can give us some recommendation that which will be really helpful for IBBI to see how we can further strengthen our IBC framework. Many of the times, the IBC has been criticized on two accounts, that is delay and the haircut to the creditors. It is important to see that IBC prescribe a very stringent timeline, either for admission or for that matter for the completion of the resolution process. It is 14 days for the admission and 180 days for resolution. And delays are often judged against this ambitious landmark. It is equally important to see if we are comparing the delay in resolution of the process, how we are performing in respect of the other platform also, be it a DRT or SARFAESI or Lok Adalat, and even in the erstwhile BIFR. This is another area where we feel their detailed study would be beneficial, and I would again request ISB Hyderabad if they can take up this issue. Coming to the haircuts, we have been looking into the RBI report from time to time. And one thing that has come out from this report is that IBC continued to be a dominant form of recovery for all the bankers. For example, if you see the annual report of RBI 23-24, the total recovery through all means, if I say all means, that is Lok Adalat, DRT, SARFAESI, then IBC, the total recovery was roughly around 96,325 crore, and out of which the recovery which could be met through the IBC route was roughly around 46,340 crore, 50% of the total recovery. So this is on record in the RBI, this thing, reports on the trends in banking for the year 23-24. So in nutshell, the IBC is still the most dominant form of recovery which is available to the creditors in the country. We have to say one of the salient features of IBC is once we are going into the resolution process, we want the company to run as a going concern. So what we did, we commissioned a study through the IIM Ahmedabad to see how the distress firm have performed over a period of time within 3 years of their resolution. And the sum of the results which came out through this study, I would like to share with you. Their sales for all the resolved firm, their sale went up by roughly around 70%. Employee expense grew by 50%. That is an indication of an increased employment. Then total assets increased by 50%. Expenditure surged by 130%, indicating renewed investment and capacity creation. The aggregate market capitalization of the listed firm among those, the distressed firm, it went up from 2 lakh crore to 6 lakh crore, roughly around 3 times. So this is again indicating the strong investor confidence on those distressed companies which went through the resolution process, and still they are doing, they are on this thing up a scale on their recovery path. As if liquidity too also improved by roughly around 80%, underscoring the financial revival of this company. So what now we are doing, this time period for this study was up to FY23. So we have requested IIM Ahmedabad, please take the data up to FY25 so that we are able to see that we are able to ascertain whether the real outcomes in a holistic manner, in a holistic perspective, whether there was any structural rigidity in the findings or the trend is still continuing. Another important study which had been done by IIM Bangalore, that is regarding this, how the corporate credit culture has evolved post-IBC in the last 8 or 9 years. What are the parameters we have taken for this thing is debt servicing efficiency, strengthening borrower discipline, and adoption of a higher governance standard, especially in respect of the listed companies. Here also, I would like to share the finding. There is a sharp decline in overdue loan account, which average overdue period reducing from 248 to between 248 to 344 days to roughly around 30 to 87 days between 2018 and 2024. There is a steady rise in the account transitioning back to normal from this subnormal category. When I say subnormal category, it could be a special mention account of 0, 1, 2, any of the category. Borrowers' cost for the distress fund had reduced by 300 basis points, roughly around 3%, and the governance improved with a 2.84% increase in the independent directors in these companies. The study even finds there is a small but a positive rise in the R&D intensity, signaling that there is a shift towards a long-term value creation post-restructuring. Now I'm coming to this current period. We know that the code has achieved remarkable success, yet we know that what any statute, how so perfect it is, they cannot anticipate every complexity of human enterprise, financial restructuring, or for that matter, economic reality. The true strength of any legislative, any code, lies in its ability to evolve through the regulatory refinement, judicial interpretation, and the stakeholder feedbacks. While we do recognize there are challenges associated with IBC, so far we have already introduced 60 amendments to further strengthen this framework and to reduce the delay and improve the recoveries. And what IBBI had done, IBBI on its part has made significant regulatory reforms to complement these amendments to improve the overall functioning of IBC. All of us know this IBC Amendment Bill 2025 has already been laid on the floor of the Parliament and it has been referred to the Select Committee. But I would like to share 3-4 salient features of this amendment bill. First, what we are doing, we are trying to ensure faster resolution through this amendment. The average time for resolution, currently roughly around 430 days or 420 days. What we are ensuring through this amendment that it has to be admitted within 14 days. If it is not admitted within 14 days, once the application has been filed with the proof of default, that is record of default, then the tribunal or the NCLT will have to record the reasons. We are also trying to prevent the discretion-based rejection. Once the default is there, application has been filed, and there is a record of default procured from the information utility, then it has to be just admitted, and there is hardly any scope for rejection. We are also trying to allow greater flexibility in terms of that instead of outrightly rejecting the resolution plan, if there is a scope that can be reverted back to COC for rectification. For complex businesses, we are allowing asset-wise sales so as to maximize the value for creditor. Avoidance transaction, we are trying to make it more refined. We have provided greater clarification, while we have explicitly mentioned that the fraudulent and wrongful trading will also be classified as avoidance transaction. We are also trying to minimize the elbow room for dissenting creditors. They should not use the provisions in this IBC code for further prolonging the resolution process in respect of the stress asset. We are hopeful that collectively these measures will make resolution faster, more predictable, and more efficient, reinforcing stakeholders' confidence and positioning India's insolvency framework as a transparent and value maximization proposition for the stakeholders. To sum up, as far as IBC is concerned, it's providing the resolution under this code backed by a well-defined regulation by IBBI, market-driven price discovery process, and the entire process ratified by the NCLT within the four corners of NCLT is providing a higher degree of comfort to the creditors vis-a-vis any other window that is presently available to the creditors as on date. So this is the sum and substance of how IBC has performed over a period of time. Now I'm coming to the consultation process. And which is more relevant to this conference. As we all know, the role of IBBI is to regulate the process as well as profession under the IBC, especially in respect of resolution professional, COC, or any other stakeholder. How we are doing it? There are three main pillars on which this entire consultation process is has been adopted throughout this period. One is mandatory public consultation before framing any amendment or bringing any regulation. Economic analysis of any regulation, and all the analysis are put in public domain so that the stakeholders are also able to see how this regulation is going to benefit the stakeholders under IBC. And the third is all our regulation we are reviewing at the end of the 3 years just to see what is the relevance for their country. Is there any relevance or rationale for continuing the regulation, or is there any need for repeal or amendment? I would like to share that since 2016-17, we have placed 89 discussion papers in the public domain and held 139 roundtable consultation demonstrating our commitment to this participatory approach. In the context of the consultation-driven regulation, policy research, policy design and research initiative have a special role to play. They are the bedrock for driving innovation, resolving complex cases, and shaping a better future. I am delighted to share that this year for this conference, there was an overwhelming response from the academia and all other participants. A total of 109 abstracts were received, 75 shortlisted, and 57 full papers were received for this conference. After rigorous review, 24 outstanding papers have been selected for presentation, which will be done in the coming 2 days of this conference. I commend all the researchers for their contribution regardless of selection, and encourage all of you to advancing quality research paper in this important field of insolvency and bankruptcy. This conference represents a confluence of academia, practitioners, and policymakers who are committed to strengthening the IBC ecosystem. Research plays a crucial role not only in analyzing what we have done under IBC, but also in identifying the gaps and exploring innovative solutions. I encourage all of you to use this platform to challenge assumptions, test ideas, and develop insight for better policy and perspective. The dialogue between researchers and regulators are essential to ensure that IBC remains an evolving framework which is both relevant and responsive to the emerging needs of the stakeholder, that is resolution of a stress asset for the debtors in India. This kind of engagement of IBBA with research and academia, whether it's in ISB Hyderabad, IIM Ahmedabad, IIM Bengaluru, MDI Gurgaon, this is, as a continuous process, is a reaffirmation of our shared commitment to ensure that IBC continue to meet its core objective to foster economic growth and investor confidence. I am confident that the papers that would be presented during this conference will also delve into and address some of the issues which I have tried to flag during my address to this August audience. We in the IBBI are earnestly looking forward to the issue that will be emerging out of the deliberations to be held in this conference as a guiding path for the future roadmap of IBC ecosystem in the country. With these words, I again thank IBC ISB Hyderabad to give me the opportunity to share some of my thought process from the regulator's perspective. Once again, I thank you, and Jai Hind. Thank you.
Thank you, sir, for this enlightening address and eloquently setting the tone of the proceedings. I would now like to call upon Ms. Anita Shah Akela, Joint Secretary, Ministry of Corporate Affairs, for delivering the special address. Welcome, ma'am.
Respected Shri BVR Subramaniam Garu, Sir, CEO Niti, Shri Bhushan Kumar Sinha, whole-time member IBBI, Professor Madan Pulitla, Professor Sanjay Kalapur, dignitaries of the dais, researchers, and dear friends. It's an honor to be here in front of you today on this cloudy morning in the Pearl City of Hyderabad. And it's with deep humility and keen hope that I stand before you today to reflect on the evolving journey of insolvency law in India. How the Insolvency and Bankruptcy Code 2016 has become both a crucible of commercial reforms, a living institution under constant stress and renewal. We find ourselves at a critical juncture. The IBC, conceived as a bold departure, a temple of credit discipline, value preservation, and corporate resurrection, must now be fortified by preventive architecture, institutional recalibration, jurisprudential clarity. As Kautilya admonished in the Arthashastra, that Vyavasthanam Dharmasya, which means the law is the scaffolding of order. Without robust institutions, statutes languish. Without vision, institutions ossify. Today, I wish to weave together three threads of my thought processes. One is the promise and the performance of IBC as a mechanism of revival, the imperative of a structured early warning system, the need to migrate from an overburdened NCLT to probably a specialized bankruptcy court, undergirded by recent legislative and judicial intervention. The promise, the performance, and the problem of delay which plagues the IBC today. When the IBC was enacted, it carried with it a lot of moral and economic purpose, not merely to break the insolvent firm, but to also revive the viable one, to convert default into an opportunity, to restore faith in the credit. Liquidation, of course, was supposed to be an exception and not the rule. Over the years, we've witnessed various success stories. Companies have been rescued, jobs saved, values preserved, yet the picture is uneven. The key empirical observations that we all know of, I will just repeat for a bit for setting the context. Average resolution duration now exceed about 700 days, far eclipsing the statutory target of 330 days. The recovery rates hover around 32-33% of the admitted claims. Crucially, the recovery deteriorates rapidly with delays. And when the resolution is completed within 330 days, recoveries are around 49% of the admitted claims. But where the cases are lingering beyond 600 days, it goes down to around 26%. The ratio of resolutions to liquidations has improved in the financial year 25. We observe nearly one resolution for every one liquidation. And in the quarter 4 of financial year 25, the ratio was way better. Yet, much of this progress is concentrated on high-value, large cases. The smaller or longer pending legacy cases are still often ending into liquidation and protracted struggle. These figures teach us an unvarnished truth. Delay is value erosion. Protracted distress shrinks the space for revival. One might ask, if the code is so powerful, why do delays persist? The answer lies in institutional capacity, procedural friction, and adjudication. It is this friction that motivates me to press for two structural innovations today, an early warning system and probably a specialized bankruptcy code. The early warning system, if insolvency is supposing like a critical care, then the early warning system is the primary care that detects the illness before it becomes fatal. To echo the Mahabharata injunction, Kalya Varjet Papam, evil must be eschewed in time. Imagine a regime in which the GST returns, MCA filing, the credit defaults, real-time payments, supply chain uh, anomalies, and sectoral stress indices are collated into predictive dashboard. Advanced analytics AI engine could flag signals, weak cash flows, rising debt servicing ratios, supply chain stress, allowing management, lenders, and regulators to intervene before a crisis happens. We have already seen a promising evidence of over 13 lakh crore of default have been resolved pre-admission in IBC. That tells us that informal or an early resolution not only works, it also reduces the legal cost, the value loss, and the reputational damage. But designing such an EWS is far from EWS early warning system is far from trivial. Research questions are abound. How to set the threshold to minimize both the false positives and the false negatives? How will firms respond when signals become public or semi public? What governance protocols shall be followed for a flag? Who intervenes, when he intervenes, and how and with what incentives? Can early warning signals themselves become tools for the board or the auditors to trigger corrective action? The research community here can help us map, test, stimulate, and refine these architectures. For policymakers like us, the goal is to be institutionalizing this EWS as a complement to insolvency and not a substitute, but a complement that shifts the focus of the action upstream. Now we come to perhaps the deeper structural reform, the transition from an overtaxed, overextended NCLT to probably a dedicated bankruptcy code. At present, the NCLTs are burdened with an array of mandates, the company laws, mergers, operation mismanagement, and many more. Insolvency is one of the many. The result is delay, fragmentation of expertise, and unpredictability. History teaches us that the institutions do matter. The Roman practice, the English equity courts, and even our own path of village justice remind us that specialization yields clarity, speed, and legitimacy. In modern systems, for instance, in the US, there is an empowered bankruptcy code standing full time, specialized tribunal only looking at insolvency. The UK employs the insolvency and the company's court within a specialized commercial framework. The Singapore has fashioned a specialized commercial court infrastructure that positions itself as a hub of cross-border restructuring. We must ask, does IBC not deserve an institution home of its own? A tribunal with judges appointed for the mastery of insolvency law, supported by registries, case management system, and a specialist support staff. Yes. Such bankruptcy courts would relieve NCLTs, anchor jurisprudential consistency, strengthen confidence in speed and predictability. It would align our institutional design with the ambition and the scale of IBC. For researchers, my questions here are, what is the optimal bench strength, distribution, and the appellate structure? Can we ensure coherence across the court silos without sacrificing the locally access? What comparative lessons may we learn from, say, US bankruptcy court, from the UK restructuring courts, or from Singapore commercial courts, or any other courts which have been really successful in timely resolution? The judicial pronouncements are the soul of IBC. If IBC is the skeleton, the judicial pronouncements are its soul. The Supreme Court and the High Court, through its various judgment, have sculpted the contours of IBC with precision. In fact, we had the innovative industries which clarify the twin test of default, setting a creditor-driven tone. We had the Swiss ribbons, V. Ramakrishnan case, Binani cement case, and various others which have really set the tone for how IBC has to be. These rulings have woven a jurisprudence that balances speed with fairness, discretion with oversight, echoing the Rig Veda's call, which says, Sangachavavam Samvadam Sambo Manamasi Janatam, which means move together, speak together, and let your minds be united. Our 2025 amendments which have been placed before the parliament, I will not repeat them again because it's already been told by my predecessor. But yes, the rationale behind these amendments was to reduce the time delays, to improve the recoveries, The timelines have been set very clearly. They were set earlier as well, but the courts have held them at directionary. We are looking at natural justice to be given in a commercial judgment, where I need to listen to all the parties involved, thereby leading to delays. So we've had a number of consultations on these issues, and with that, we came out with the key amendments that have come in. But are those amendments the be all and the end all, or are they just band-aid? Only time will tell. The new things that we are looking at are the creditor-initiated insolvency resolution process, wherein the creditor and the debtor together in a cooperative mechanism come out with a resolution plan which ensures that the company remains with the debtor and they are able to move forward. And they finally go to NCLT only after this thing is settled. So this is one regulatory sandbox kind of an experiment which is being done by us. How it plays out remains to be seen. Then we are also looking at the allowing cross-border insolvency, group insolvency. How that plays out remains to be seen. For cross-border insolvency, what would be a good way of going about? Adopting the ancestral law per se? Do we look at something else which probably suits us way more? Would the existing NCLT setup be good enough to be able to handle these cross-border insolvencies, or do we look at a specialized bench only to handle cross-border insolvency? These are various questions that are thrown up again. Then and as researchers, as I say, you can help us to build and validate predictive models for the EWS, early warning system, stimulate institutional design for the bankruptcy court, assess the impact of the amendment and the judicial rulings in sectoral detail, study the behavioral responses of the firms, creditors, and courts, propose refinements, institutional safeguards, and comparative benchmark. Allow me, in closing, to recall a Sanskrit aphorism. Yoga karmasu kausalyam. The skill lies in action. The IBC is not merely a law on the statute book, it's a living instrument. Each amendment, each judgment, each resolution plan shapes its destiny. If we succeed, if we embed early warning system, sharpen adjudication through specialization, protect both credit discipline and human dignity, then the IBC will not merely be a reform of the past decade. It will become a pillar of India's economic resilience, the institutional architecture for distress revival in a dynamic future. IBC ensures that the enterprises live not in the fear of failure, nor mired in endless litigation, but in the sunlight of second chances. From an experiment in 2016, it has grown into an institution. With early warning system, dedicated court, visionary reform, it can become a legacy. To you, the researchers, I entrust the IBC's next decade. Your insights will shape a regime that deters default, rewards revival, and fosters trust. Let us heed Rigveda's call to unity and build an IBC which is not just a code of insolvency, but a covenant of the economic renewal for a Viksit Bharat. Thank you so much.
Thank you, Madam, for this informative address. Now it is my indeed privilege to call upon our esteemed chief guest for the occasion, Mr. BVR Subramaniam, Chief Executive Officer, Niti Aayog, to kindly address. Thank you, sir.
Professor Madan Pilutla, Dean of ISP, respected dignitaries on the dais, and respected members of the audience. I feel honored to be invited to speak at this international conference at ISB. You're all experts in the subject, and I think this is a very important topic, which is fundamental to the realization of the dream of making India the world's third largest economy, or a $30 trillion economy by 2047. Now, we've heard two speakers. One has set a context, one has set what the current situation is and what the future can look like, or what needs to be done by researchers. I want to take a slightly different approach to the whole thing. I don't see the IBC or IBBI as law. I think it's a fundamental economic institution. What is capitalism about? Capitalism about creativity, creation, and destruction. So destruction is as integral to a capitalist economy as creation is. It's not only about not forming new organizations and structures, it's also about destroying organization structures which have outlived their utility. I think that is fundamental. And just as we focus on ease of doing business, ease of entry of firms, ease of setting up new organizations, there also has to be ease of exit. Ease of exit can be either voluntary or forced or failure or mala fide. But I think exit and entry are two sides of the same coin. You can't have one and not have the other. And if there has been a problem with the Indian economy till the 1990s, we had entry, which was regulated, and which we had exit, which was impossible. If you have this kind of situation, it's like, old fashioned, you remember the third class compartment in an Indian train, you only had people getting in, nobody getting out. And that's what happened to the Indian economy. So I think capitalism is all about efficient allocation of resources. And they go to the best firms which are best placed to deliver value to the economy, create employment, create productivity. So I think if you do not allow creative destruction, economies ossify. And wherever you see economies ossifying, wherever countries going down the economic path, it's largely because of this. They have lost the creative impulse, not only to create, but also eliminate. So I think that is something fundamental. And there is a second issue, which is a much narrower issue, but is also there. Because of excessive focus on bankers and lending, and that's what one hears very often, I don't see IBBI or the Insolvency Bankruptcy Corp as a substitute for bankers recovering money. They are just one player among many. If there is even zero recovery and there is a 100% haircut, but you have a living entity, there may be greater economic value to the economy as compared to the bank. Banks are just one stakeholder in the entire process. I mean, the General Motors you see today was not the General Motors which was there 20 years ago. In 2008, General Motors actually shut down. It was taken over, it was made insolvent, it went bankrupt, and what you have is a new company, General Motors Corporation. The airline you fly in Swiss is not the Swissair which was there 20 years ago. That's why they don't write Swissair anymore. You just Google and you will read that it was Swissair 20 years ago. It is Swiss now. Went bankrupt, but as a living entity, entire assets and the employees were transferred in a new organization. It's actually a Lufthansa subsidiary, and it runs. So I think that is the way we have to look at it, that the creation of both passing of the law, which is the IBC law, as well as creation of the body IBBI, is integral to making India an advanced economy, without which it cannot happen. I mean, the country cannot progress unless you have had some such thing. Just as you replace the MRTC with new laws, just as you change all the commercial law systems into more modern versions, I think the IBC was a step in that direction. In 2016, you created a body which was fundamental, without which we would not. I mean, even if you go back further in history, very often, countries don't grow because of just scientific developments. Scientific developments is just one leg of a four wheels. And another important wheel is organizational structures have to evolve to capture the developments of science. I think Asia, Europe were equally good in science. Maybe Asia was far ahead for thousands of years. But we all had similar organizational structures, and therefore we succeeded. And Asia was probably richer. India was, Sone ka Chidiya, 25% of the world GDP. China was similar, and Europe was lagging behind. What was one fundamental thing which made the difference around 1700? People think it was, Edmund Cartwright inventing the spinning jenny or the steam engine by whoever, James Watt or whatever. No, it was not that. It was the creation of a limited liability company and a joint stock company. The Asian world didn't have one, and the Western world created one. That led to a fundamental explosion of creation of capital, accumulation of capital, because you separated an individual and an organization. And that limited liability company led to capital accumulation. I don't think science in India at that point in time was worse than the science in Europe or wherever when the initial things happened. I think science was equal. We didn't create the organizational structure. That organizational structure led to the boom. And remember, who colonized us? Not the British government. East India Company. It was companies which colonized Asia and America. And I think, who colonized Canada? Hudson Bay Company. That's it. So I think we have to realize that institutional architectures are extremely important for the development of nations. And once you've created, and just as human beings are born, they have to die one day, and that's the beauty of God, that we exit. So we leave space for a new person to enter. I feel happy that I'm going to retire. I have retired, actually. I'm here maybe another 2-3 years. Out of the picture, there'll be a new blood coming in. We need the same thing happening when you created a new kind of a human being, which is called a company. It has to come in and it has to die like human beings die. You pick up any Fortune 500 list of, say, 50 years ago and see the top 50 companies, barely 25% will be same from then till now. The top 5 market-listed companies in the United States were not the top 5 companies 25 years ago. And the total valuation, they exceed the GDPs of India, at least the top listed company, NVIDIA's. So this is something which is fundamental, and I think that is the lens through which to see the insolvency and the resolution process. How is it playing a part in the larger law? Be it lawyers, be it economists, be it accountants, be it resolution professionals, I think that's it. What did we have before 2016? We had a very patchwork of way of doing it. We had civil courts, later on we had debt recovery tribunals, then we had SURFACE. What is all it about? It's about how do I get my claims quickly out of the thing. It is not a business-oriented or a market-oriented approach. And this patchwork led to all kinds of problems. You have delayed, low recoveries, very dysfunctional behavior. I could game the system. And what happens is who succeeds? The people who can game better, not entrepreneurs, not people who are creative. And even the old system's entire focus is on asset recovery. That's the constant hum which you hear. How do I recover? How do I recover? I said that is incidental. Just as organizations can fail, companies will, even banks can fail, and they fail. You had that 3 years ago in the United States, a chain of banks failing. That didn't mean the US economy collapsed. That's as much a part of it. I'm waiting for the day when a bank comes to an IBC for resolution. It has to come, one day. There's no doubt about it. And therefore, in the earlier systems that are there were no incentives for early settlement. People could drag it on, people could use the legal system to delay, and it is what would I call debtor-friendly. And if you're in a debtor-friendly system, you game the system, and you don't have outcomes which are actually economically efficient. So then there's been a lot of evolution. What was there before 2000? You had civil courts, you had lok adalats trying to settle these things, etc. And so biggest problem was how do banks couldn't even enforce security. You couldn't take possession of mortgage properties. So I think that was the kind of situation. So then you came up with the DRTs, etc. in 93. First step, it was after the 91 reforms that the DRTs came up. Slum improvement recoveries rose from 2% to 5, 8% or whatever that the DRT system had. And you could make some improvement. Again, but then DRT system, bankers would be familiar, lawyers would be familiar. You could use the legal tools to delay processes. And then you evolved to the next system, which you had the SURFACE Act. It gave more powers to banks to actually directly do things. You also created the asset reconstruction companies because of SURFACE. So some improvement in that. So you had these recoveries coming up also from, you had 2% recoveries, 10%. The moment you had these SURFACE recoveries rose to 20%. But again, what was the focus on? The word is recovery. Recovery meant asset recovery. So, it's almost as if it's a creation for bankers. I don't see this as a tool for bankers to do their jobs better. I see this as, what a Chapter 11 in the United States or whatever you have in the UK, etc. It's not about recovery. It is about first, am I going to convert a liquidity issue into a solvency issue? Can I prevent that? Most companies, the red flags in the early warning system, which my colleague from Corporate Affairs said, Mr. Akella, that, can we have an early warning system? Early warning systems are all liquidity issues. And if you actually generate enough liquidity at that point, it doesn't become a solvency issue. I think that's something. And mind you, a lot of banks don't realize that. Most financing entities don't realize that because the very rigid structures within which we operate. And that's what, say, the Chapter 11 does. The moment you put a company under Chapter 11, you freeze things. And then you give time. It's like, a patient is there. You have to take them to a hospital. You can probably save the person in the hospital, but in between, you have to give oxygen, give some injections, whatever. It is that. So I think that's what an insolvency process does, and that's what probably we have done. That we have created the IBC, we've created the IBBI, we've created a process. It came through in 2016, and I think there's been a dramatic improvement. Let's be very, very clear. We must be proud of whatever we've created. What IBBI, I knew his predecessor chairman, current chairman Ravi is a good friend. They have done a wonderful job. Even if you focus narrowly on recoveries or whatever, they have risen. People may be unhappy, whatever, and we are taking haircuts. But 30-40% recoveries compared to say 2% 30 years ago is far, far better. It's an improvement. There are dramatic cases where there have been 90-95% recoveries also. But more important for me as an economic actor, because it helps preserve value. And it has preserved value in a large number of cases. We are currently sitting very happily, less than 3 days from a landmark Supreme Court judgment, which reversed its own judgment of May on Bhushan Steel, JSW. Am I right? So it was a death blow in May, and the IBC was dead in May. Let me be very clear. That is what me, Principal Secretary, and others were discussing, and Cabinet Secretary. What have we done? What's going to happen next? Because as I see it, this is not law. This is part of a market architecture of an advanced economy. You suddenly kill that leg, let me tell you, the market collapses. Why does London continue to be one of the centers of global capital? Not because it's a global economy. It's a very third-rate manufacturing power, very mediocre in most sense. But in London, it has got the entire ecosystem of finance, including insolvency, legal professionals, accountants, everybody. So people would like to have London as the jurisdiction for closing a deal. And that's where finance is rooted. 90%, London pension funds don't invest anything outside UK. You can't name one London pension fund. But every other pension fund in the world or every other sovereign fund roots their money through London because of the ecosystem. If you have to become a global financial capital, if you want to become a third largest economy, you need to be doing this within your country. And so the IBC was very critical, and it's thankful that the Supreme Court actually went back on its own judgment, and actually it has revived the IBC process, which one was very worried about. The beauty is now you have a single comprehensive framework where things can be done. For all its flaws, it has set deadlines. Now you may not be adhering to deadline. You may be taking twice as long. 300 days, you're taking 600 days, but doesn't matter. 600 is better than 1,000, right? So there's always a way of looking. Is a glass half full or half empty? There's a way to look at that. It's also become creditor driven. So creditors can actually drive the process. I don't have to wait for some event to happen before this whole this. It has also strengthened creditor rights. The waterfall mechanism and all that have been set up. It actually makes the creditors pretty sure of where do I stand. In the entire in the sequence of claims that is there. Also, the predictability of outcomes becomes far more easier. So that becomes so. I'm saying all this because this is where the problems also are. So, their problem almost can map up to all the pluses that it has delivered. But the most important is it has created new structure. The NCLAT and the NCLT, the IBBI itself. But more than that, a class of people called resolution professionals. The Committee of Creditors is a new creation which has come out. So all these put together have enabled this wheel to move. And in the almost, we are going to celebrate a decade next year. I think it has moved far enough to understand, A, that it works, and B, there are gaps. I think so we know both of it, and I think we need to address that. And they're coming up with newer and newer innovations. There's some more amendments coming, etc. And the impact is very clear. The unified framework has led to a lot of predictability all around. It has defined rights of creditors. So I think that's very, very important. So creditors now know this is there. It has restored, business confidence and also the capacity of the system to keep businesses alive as going entities. I think that's there. It's what we don't realize is creating a functioning business at an organizational level is actually a lot of effort. And if it vanishes, that is a great loss to the economy. Creating it all over again is very, very, very difficult. If Microsoft vanishes tomorrow, creating another Microsoft with all the other things that it entails, the kind of ecosystem it supports, is going to be a very, very difficult exercise. So retaining entities as going concerns, I think, is one of the advantages of IBBI, and there are any number of cases. So I would look at that. Just as the liquidations are as important, equally important are the number of cases which have enabled companies to survive, and I think that is there. it also boosts investor confidence. And so because everybody knows that there is an exit route through which, I can recover. So, and you can sign up for an Indian jurisdiction or an investment in India. But I think the most important thing, and it was alluded to by two of my speakers, it has led to a cultural change, a behavioral shift. I can lose my company. I think that's very, very important. The gaming of the system, which was quite rampant earlier, and mind you, I don't believe they are crooks. If a system is weak, I will take advantage of it. This human nature. And I think that is what is happening, nothing else. You have to close the doors, you see. You can't say that, if there's money lying on the road and just you're walking past, the two fellows who may just walk past, third fellow will just pick it up. Am I a fool not to pick up that 100 rupee note? Absolutely silly. I may use it for whatever, I may give it to charity. I'll pick it up. So this is what the Indian system was. It was full of loopholes and everybody was gaming the system. I think IBC, its creation and the code itself has led to a change in behavior. Owners know I can lose my company. And I think they are more careful about defaults, and they're more careful about, live within your means. Things about, we used to have this story, if you have good friends in the old generation of businessmen, and they would tell you, that the day the company, the factory is inaugurated, I have a party at home because I've already recovered my investment. So anybody who knows, how financial accounts are, fudged or, overinflated can figure that out. But now that comes to challenges. I think the delays are an issue. So just as we have timelines, but I think the delays are a matter of concern. I myself attended meetings where this, struggle is going on. So now delays, we have heard that delays lead to value erosion. But the question is, how do we cut delays? And let me tell you, often we think, throwing more judges into the pool can reduce delays. I doubt it. I doubt whether you throw more manpower will reduce delays. I think there are structural issues which need to be resolved. You have to reduce the opportunities for delays. You have to reduce processes which cause delays. Not, throwing more people at a problem doesn't solve it, You need to actually do that. So it could be process, it could be legal, it could also be complexity of cases. And which means you have to, I don't think no law can handle every possible situation that is there. So you have to allow flexibility in the system to do it. That is there. These haircut issues, of course, will have to be resolved. My predecessor did speak about it. But the inefficiencies, both in the committees of creditors as well as in the NCLT system, should be seen. I know judges who are unwilling to become chairs of NCLTs because of the workload there. I know. They don't want to. 30,000 cases, who wants to spend my time clearing all this muck? Now, if you have a clogged up system, you don't expect any solution. So I think, there are suggestions we have heard, not that one is saying for or against, but we need to look de novo. How do we speed up? And there's another thing, because we were not a very developed country 50, 60 years ago, our legal system had a certain tilt towards it. But as you grow as a country, and we have grown, and we are the fourth largest, fifth largest economy in the world, your economic activities in courts actually will increase dramatically. I would like to look at the number of judges, lawyers, litigants who are very, very familiar and confident about economic law. I think those numbers have to be increased, and that's something which is there. There is one thing in the entire process, and I remember that, I forget the buildings case in Delhi. I don't know who it was, where there was an NCLT process and then it had to be struck down by High Court or Supreme Court or whatever. There you had this, I think it was JPE or whatever, where your problem is, buyers of houses get let out. So, operational creditors, other creditors in the IBC process actually feel left out. So I think their voice also has to be seen. I think the system can correct that. It's nothing major. There are a lot of other issues, complexity of cases, cross-border issues, again, alluded to by my speakers. We need to do that. You have to understand that in societies like ours, which are developed economies, which are becoming large, there'll be more and more complex business structures which will keep coming up. I'll give you an example. We don't exist in India. Some finance professionals, one of the biggest things that happened in the last 5 years in the US, now it's waning, is the institution called SPAC, Special Purpose Acquisition Vehicle, company. They don't exist in India. You create a company that instead of merging, you buy that company and you don't have a listing problem because I'm pre-listed. Okay. The SPACs rose, SPACs fell, a lot of SPACs went defunct. If that kind of a case comes to IBC, how will they handle it? Probably we don't even have expertise. How do you value these kind of assets? How do you value these companies? So I think we have to plan and design structures which can handle complexity that is there. And Also, how do we help our MSMEs? I think they've come up with some, framework which allows, some kind of a set pattern through which they can do it. But I think we need to work that. I think the large company issues can get resolved in the existing frameworks. But I think MSMEs are equally important to be, they are the ones. I'm a startup. I've taken $1 million or 1 crore of rupees as a loan, and then I fail. And I need to exit. And I need not be tainted because of that personally. I don't believe that everybody who fails is a crook or they've failed because there's malafide. Industries or organizations fail because the time will come when they will fail and they're unable to keep up with the developments in the market. You should allow them to fail without the owners being taken. And MSMEs have the largest problem in that, and they'll come in hordes. In numbers will be large. So I think that's there. So some solutions, one of course expand capacity, but I think reorganizing the act, the processes, the flows, automating, bringing technology, digitalization, all that would actually help. Also improving the quality of our resolution professionals, etc., has been alluded to. I think that also is there. Also, there are newer issues which should be looking at. We are looking at individual companies failing, but the companies could be part of larger groups. What happens to the chain? Are you also looking at group liability, about groups being responsible for their subsidiaries? There are situations where they need to be treated separate, but there are situations where they need to be treated together. I think these are issues that need to be addressed. And last but not the least, just as the ARCs played a good role in enabling SURFACE and others to work, we need strong secondary markets for failing companies. So some mechanisms will have to come up where failed companies are resolved and they are available back in the market where people can invest, etc. That will attract institutional investors. In the long run, there's more money made to be made from a junk company than from a running company, because the upside is going to be huge. A penny stock, and if that company has value, can suddenly rise tomorrow. I mean, again, I'll quote what was NVIDIA 20 years ago. It made some small kind of a chip, the most valuable company on earth today. It's technology. So I'm not saying it was bankrupt. So similarly, in the entire resolution process, we need to create deep secondary markets which can invest then in revival of these companies. That will require new forms. We are still seeing it in terms of, how much can we recover? What can we do? I think if the focus shifts to how can we actually keep organizations as going concerns, that I think is one of the biggest values that is there. You see, you look at our airline industry, it's become a duopoly, literally a duopoly. The other two have probably one foot in the grave. But the point is, how do we keep them going? It's not good for market structure to have these kind of duopoly. A telecom sector is a duopoly from a dozen companies. How do we keep these things going is something. The government does its own. I mean, after all, the government has kept Voda going just to see that it doesn't become a duopoly. Similarly, I think it's a responsibility of organizations which enforce market structures, and in a way it is enforcing a market structure by helping companies to be alive. They should look at new ways of actually creating capital flows which will keep companies going. I think researchers have a lot to do, a lot to think, because you explore the frontiers of knowledge, and what you then come out with gradually feeds into both policy as well as law. Thank you very much, and I wish you all success over the next 2 days.
Thank you, sir, for your kind words and sharing your thought-provoking perspective. Moving forward, we are delighted to announce the release of our research publication titled Transforming Insolvency Resolution in India. This volume brings together 12 meticulously curated papers presented at last year's 3rd International Research Conference on Insolvency and Bankruptcy held at the Indian School of Business, Hyderabad. This distinguished compilation reflects a rich and diverse discourse on the Insolvency and Bankruptcy Code, capturing its evolving impact on the Indian economy and its stakeholders. To mark this occasion, may I have the honor of inviting the esteemed dignitaries present on the dais to formally unveil the publication. Thank you to the dignitaries present on the dais. I would now like to call upon Professor Sanjay Kalapur, ISB, to deliver the vote of thanks.
Respected Chief Guest, Mr. BVR Subramaniam, other dignitaries on the dais, and all the members present. It's a pleasure to give a vote of thanks for such an important event. As Mr. Dr. B.K. Sinha told us, the IBBI is looking for research inputs, and IBBI, through its this is the fourth research conference, has always been committed to supporting research. Very early on, they also set up a research guidance group, and they offered to make data available to researchers. So all the researchers present here, this is a great opportunity for all of us to do research that has a bearing on practice. Um, I thank the Indian Business School of Business for supporting research, making possible events like this, which bring together policymakers as well as practitioners and researchers, so that there is a rich discussion among them during the papers presented in the conference, as well as outside during breaks, which ultimately can help to answer all the questions that each of the three speakers have put forth before us. They have given us the challenges. They have told us what questions they would like answers. Those are the challenges before us, the researchers. And I'm sure you have all taken notes and will put your thoughts to those questions. Mm. So, Mr. Subramaniam, thank you for putting the insolvency and bankruptcy regime into a broader context and telling us about the importance of this whole mechanism. As you rightly said, it is the organizational arrangements that made the difference between what the Western countries are now, and where other countries have been left behind. I will add one more thing, that one more organizational arrangement that the Western countries did first, which is the peer-reviewed science, the Royal Society for Science and all those institutions. That was, along with the joint stock company, that was one very important institution which has led to the rapid progress of science. Thank you, Ms. Akela, for putting forth candidly the successes as well as the problems before the insolvency regime, and talking about two bold new initiatives that could be done, which is the early warning system and specialized bankruptcy courts. Thank each of the speakers, thank ISB, thank IBBI, and finally, I thank all of you, the participants in this conference. It is your enthusiasm for research and for debate that makes events like this a success.
Thank you, sir. I now request Professor Sanjay Kalapur to please present mementos to our distinguished guests. To our chief guest, CEO Niti Aayog, Mr. BVR Subramaniam. To our whole-time member, Insolvency and Bankruptcy Board of India, Dr. Bhushan Kumar Sinha. To Dr. Bhushan Kumar Sinha. Thank you, sir. Thank you to the dignitaries present on the dais. Ladies and gentlemen, we will break for tea now. Please join us back latest by 11:40. Thank you. I request everyone to kindly be seated. We now move forward to the academic keynote address. It is my honor to invite Mr. Dushyant Vyas, Professor of Accounting at Toronto University, to deliver the keynote address. Welcome, sir.
All right, good morning. So first of all, let me begin by thanking the organizing committee, particularly Hari Om, Apurv, and the IBBI team for putting together this conference on a very important topic. And also thank you for including me on the program. It's an honor to be presenting here in front of such a distinguished audience, in front of such distinguished guests here. I know that it's a mixed crowd here with people who are from various backgrounds, practitioners, regulators, academics, researchers. So here, my objective here is to present to you, essentially a summary of inferences from several decades of research, empirical research on creditor rights. Okay? And I'll be remiss here if I did not thank Christine, one of our former PhD students and my co-author who's helped me prepare this presentation and also helped me go through just a huge volume of literature that is out there. You know, for those of you who are academics over here, you would know that there's virtually a sub-industry in finance, accounting, as well as in economics on understanding the various dimensions of creditor rights and its various consequences. You know, so we are merely scratching the surface here when we are trying to understand creditor rights from the perspective of what has been found and what has been discussed in academic research studies. Okay. So here's my plan for the day. I'll start with a bit of a background, just a brief introduction, followed by a summary of literature that has been that is largely in the international context. So I'll go through a few, again, without getting into the minutiae of the regressions of the findings there, just some key takeaways from this long and very extensive literature on law and finance. Okay. I'll also talk about a few recent developments in North America, which I think could be quite salient and which could have some implications, ramifications in the Indian context as well. Particularly the rise of these so-called pre-plan outcomes, you know, which is indicative of secured creditors asserting their rights through the insolvency process in the US as well as in Canada. And then some more stylized facts, including some emerging research evidence on more recent phenomena, such as the prevalence of these so-called liability management exercises, which is sort of colloquially referred to as creditor-on-creditor violence. Okay? I'll end the discussion with a very brief summary of what research has found as far as the Indian setting is concerned, and then just discuss a few brief takeaways and implications. Right? So, and you'll see that some of the themes that emerge from the research evidence are the very points that our distinguished speakers from the earlier panel talked about. So, you know, creditor rights mean all sorts of things to different people. Okay? It depends upon the context. It depends upon who you're talking to. Okay? So, if you open up the financial newspapers worldwide, you know, you'll see that there is renewed emphasis, a lot of interest in topics that talk about creditor rights from a variety of different dimensions. You know? So, from the European and the UK context, for example, there is talk about moving towards a more restructuring-friendly regime. You know? So these used to be countries which are supposedly where the systems were more creditor-friendly, which are now moving towards a more Chapter 11 style restructuring system, okay? Or at least permitting the possibility of such restructurings. On the other hand, if you go to North America, there is a lot of chatter about what I just mentioned a couple of minutes ago on the so-called creditor-on-creditor violence, where seemingly sophisticated creditors are having their rights being subordinated by not the debtor or any government agency, but by other creditors. All right. And then moving on to the Indian context, which is obviously the topic of discussion in this conference, which is developments related to IBC. So really, you have different economic levers that are being pulled in different directions. So in some instances, you have developments that increase the rights of some creditors, whereas in some other instances, you have developments which are reducing their rights at the expense of other creditors. Okay? Right. So how do we cut through all this noise? The question is, what do strong creditor rights even mean? Okay? How strong should these rights be? What are the different dimensions? How do they interact with the other institutions that are there in the economy? And ultimately, I think the proof is in the pudding, in the sense that are there any tangible, are there any sort of real economic consequences to creditor rights and developments in the strength of creditor rights? Okay? And I'll try and unpack some of this through the lens of academic research. Right? So just taking a step back here, I think academics in the audience would be very familiar with this foundational study in financial economics. All of us cite it almost indiscriminately in all our studies. But really, the point that this paper is trying to make here by Jensen and Meckling is that a firm is essentially a nexus of contracts. Okay? So if the objective is for the firm to be operating efficiently, then the nexus of contracts that form the firm, that give rise to the firm, should also be efficiently structured and implemented efficiently as well. Okay? So this is one aspect of this paper that doesn't get a lot of attention in our literature. The focus obviously is on the agency theoretic view of the firm. But Jensen and Meckling also make a point that for contracts to operate efficiently, the legal system or the milieu in which they operate needs to be efficient as well. And they're not just talking about the laws, but they are viewing the legal system holistically, including the laws that exist on the books, as well as the implementation or enforcement of those laws. Okay? Right. So this is just one characterization of what creditor rights are. And as you can see, it is, even when I've tried to simplify it, it looks like a pretty complex web. Okay? So at the heart of it, creditor rights are simply rights that are conferred to creditors to protect their investments. Okay? And these rights can arise informally through social customs, norms, etc., which might be relevant in some lending contexts. For example, in the microfinancing context, these social norms, customs, they become quite relevant. And these rights can also be a result of enforcement of law, or in other words, these rights can also be legal rights. Okay? But within this, there are multiple elements. There are different dimensions to creditor rights. Okay? As we'll see, a large part of the literature tends to focus on the rights of secured creditors, okay? Which is fine. And in many contexts, maybe that is the only relevant part of the capital structure that we need to be looking at. But in this discussion, I think a lot of nuance gets lost. Okay? But there are other elements of creditor rights, including rights of other types of creditors, including unsecured creditors. Within that, there has to be consideration for the rights of trade and other operational creditors. There are some creditors that arise involuntarily, okay, as a result of the way in which the firm operates. Okay? And these rights then have to interact with other parts of the system. Okay? And I think a very important part of the overall legal framework of a country, of a jurisdiction, is the framework for property rights, which has a direct bearing on the strength of creditor rights in that jurisdiction, right? And as the panelists in the earlier session mentioned, rules are rules, no doubt, but then those rules have to be implemented, they have to be enforced. So if there is one recurrent theme that will flow through the rest of the presentation, is that for any country to be able to realize the full extent of benefits from the laws that they have on their books, these laws have to be efficiently enforced. Okay, and there is plenty of research evidence on all these dimensions. So let me start with property rights. Okay? So let's take a step back here. Okay? So this is an excerpt from this well-cited book by De Soto on the so-called mystery of capital, where he talks about the fact that in many underdeveloped economies, a lot of capital is left untapped. Okay? How? Because formal property rights, formal registration systems, titling systems have not been developed. Okay? So those assets cannot be monetized in some sense, because these rights are not formal, property rights are not formal, and as a result, they cannot be transferred. Okay? And as a result, those assets cannot be used as collateral for getting access to credit. Okay? And there is a long line of literature in economics as well, which talks about the notion of property rights and how developments in property rights, how property right reforms, how they result in socioeconomic consequences. Okay? But again, this literature as well, it highlights the fact that property rights are important. Okay? Formalization of property rights is important, but these systems can be rather easily implemented. So, and several countries around the world, after the push in the 70s and 80s, they moved on to formal property registration systems, but yet they haven't been able to realize the full extent of benefits from this formalization of rights. And the answer there is that the benefits of these formal property rights is limited by the extent of enforcement, by the efficiency of enforcement that exists in these jurisdictions, in these countries. There's also some other research. On the one hand, you have the importance of having formal property rights in the first place, having good enforcement, efficient enforcement. And on the other hand, there's also research which talks about the fact that it's not just having formal property rights for certain types of assets, expanding the menu of assets that is potentially available as collateral. That also gives rise to increased availability of credit, and which in turn has positive consequences as far as investment efficiency is concerned, productivity, as well as allocation of resources to specific sectors. So there's a couple of papers over here that were cited, wherein they look at the ability to collateralize or to use as collateral movable property. Okay? So a lot of countries initially, when they began formalization of property rights, those extended to assets that were inherently fixed, okay, such as land and buildings. So when the menu of collateral available was expanded to movable property, all of a sudden now credit could be available much more at a much more reasonable price to industries, to sectors which had such assets in place. Okay? There is also, you might say that a lot of the discussion about property rights relates to tangible assets. So these are all old economy assets. Okay? But there have also been developments, especially in the US context and elsewhere as well, where the focus has then moved from simply using tangible assets as collateral to using intangible assets as collateral. And this is rising in popularity, particularly the use of patents as collateral. And again, research on this topic, I'm not getting into the details of the empirical specification employed here, but the broad inference from this research as well is that when creditors have access, or when creditor rights over a particular collateral is strengthened, that has all sorts of positive consequences, including in this case, more investment in R&D, improved patenting activity. Okay? So I think so far the papers that I've talked about, they give you one consistent message, okay? That as rights become more formal, as they get formalized, and as they are well enforced, And as the menu of collateral increases, that has positive effects, beneficial effects for availability of credit. Now, let me change gears a bit and go to a stream of literature again, which is for those of you who are academics, who are familiar with the finance and accounting literature on this topic. Really, the foundation for a lot of literature on this topic, on creditor rights, goes back to a couple of papers which are sort of collectively referred to as the LLSV papers, okay, or Laporta et al. Papers. Okay? Now, it might sound very simplistic, it might sound pretty obvious, but this was really the first systematic attempt to study the strength of creditor rights across all countries. I mean, so Laporta et al., they started off with a sample of around 40 odd countries, which was later expanded by the next paper that I'll talk about. Okay? So whereas that's an advantage, the issue with this early literature was that they viewed creditor rights through just a unidimensional lens, which is, in their definition, in their books, creditor rights were effectively the rights of the secured creditors. Okay? So anything that diluted the ability of the secured creditors to essentially go and seize collateral upon default by the borrower was seen as a negative. Okay? So any guesses as to where the US would land up over here? In the US, as somebody mentioned earlier, it's a very debtor-friendly system in the sense that as soon as the company files for Chapter 11, okay, voluntarily, an automatic stay is in effect. Okay. Now, during that stay, the rights of the secured creditors are stayed. Okay? There's a moratorium which is in effect, and that is seen as a negative. Okay? So, countries that were more reorganization friendly did not score too well on this index, whereas some other countries, and I've listed India over there at the bottom. It's not a complete list here on this slide, but India, as it turns out, scored quite well on this index. Okay? And the reason was that they coded the strength of creditor rights based on the 1956 Companies Act, which was later updated by some of the other papers. Okay? So there were some outliers over here, US, Canada, Australia, etc. They scored very poorly on secured creditor rights per se, but those outliers notwithstanding, and I promise this is the only regression that I have in this presentation, but the weight of the evidence, despite those outliers, was that creditor rights, strong creditor rights, gives rise to more developed, or is associated with, let me be a bit more precise in the language here, is associated with more developed debt markets. Okay? Now, just as a caveat, all these cross-country studies, which are essentially creating some sort of an index of creditor rights and correlating that with different country-level outcomes, these studies, of course, they're important in our understanding of how these rights have developed, how the law is developed, how they are placed along with other institutions. But they suffer from one single problem, which is it's very hard to pin down the exact effect of creditor rights per se on the various outcome variables. So whether it's a result of creditor rights or is it a result of other institutions which tend to be correlated with creditor rights, that's not very easily understandable as far as these studies is concerned. But with that caveat notwithstanding, I think these studies were very important in shaping our understanding, at least from a research perspective, on what creditor rights are and what are their consequences. So there's another paper here by Yankov et al., another very influential study, which essentially expanded what I just showed you from 40 odd countries to 133 countries. Okay? And they also, by the way, corrected the LLSV error that was there in the for the India score. So they updated that score for various countries, and they expanded the set of countries. The other important innovation over here was that they recognized that this characterization of creditor rights is inherently incomplete. It needs to be considered along with other elements of the institutional system framework that these laws operate in. And the one that they chose was access to information through these information sharing institutions, public registry or private bureaus. And the gist of this paper as well as several follow-up studies over here, was that both legal rights as well as information sharing or access to information is equally important for availability of private credit. Now, next, I mean, these, as I mentioned, these papers were very influential. They were followed up with multiple other studies, again, cross-country studies, so you need to take it with a pinch of salt. But nonetheless, these studies played a very important part in sort of expanding our understanding, or deepening our understanding as to how creditor rights work. Okay? What is the mechanism through which they have all these country-level impacts? So these, the next set of papers, they went a little bit macro to micro, and they examined what were the micro level, or what were the, in this context, right, what are the loan level consequences of the way in which creditor laws are written. Okay? So, for example, this paper talks about the fact that strong creditor rights obviously make lenders more comfortable with taking on more risk. So it's associated with longer maturities, lower loan spreads, and also with they also make foreign creditors more comfortable as well. Okay? So, I mean, broadly speaking, the mechanism is that these macro level factors, they impact micro level outcomes, which then get aggregated to produce the other macro outcomes that we just saw in the prior studies. Okay? And again, as I mentioned earlier on, right, the consistent theme in the literature has been that yes, laws and rules, policies are important, but what is equally, if not more important, is enforceability. Okay? And so there's another paper which basically took that stance, and they showed that they did almost a horse race between the strength of creditor rights as it appeared on the books, along with enforceability, and they find that enforceability is equally important. Then the literature developed to look at all sorts of secondary and tertiary consequences. Okay? So, for example, what are the impacts on firms? How do creditor rights, or strong creditor rights in this case, how do they impact the ability of firms to take on more risk or innovate? And the answer over here was at first counterintuitive, you know. But if you think about it, it does make sense. So if you have a system which is very, very secure, creditor friendly, which essentially gives rise to an increased possibility of liquidations, that could deter entrepreneurs, managers from taking on excessive risk. But at the same time, it could also make them excessively risk averse as well. Okay? So the next set of studies that I have over here, they essentially highlight this trade-off, and they show that there could be unintended consequences of setting the system as very rigid and too creditor friendly. Okay, but there's a fear of liquidation, and this will come through in the Indian setting as well, where I'll describe one paper which essentially documents this in the SARFAESI context. Okay? Numerous people have taken this cross-country approach to various other outcomes. So we just saw the effect on firm-level outcomes. What are the effects on banks? So there's the evidence over here is quite mixed, because mind you, a lot of these studies are cross-country. They are taking place over different time horizons during different time periods. So it's not surprising that evidence that is seen in one time period might not hold up in the next one. So whereas the first study over there shows that banks were more comfortable with taking risk and presumably excessive risk, which in turn gave rise to a higher likelihood of financial crisis. But on the other hand, a later paper by Heitz and Narayan Murthy shows the opposite effect. So there is an increase in probability of default. Okay? But the other element of credit risk, which is loss given default, that went down because of strengthening of secured creditor rights. So the net effect that they observed in this paper was a negative relationship between strong creditor rights and bank lending risk. Right? just very quickly over here, I talked about the fact that these cross-country studies, they suffer from some sort of inferential problems, in the sense that there are other institutional factors which will be correlated with creditor rights. So how researchers have attempted to get around this problem is by conducting studies within a particular country, okay? And by looking at specific rule changes or amendments, okay? The impact of those, as long as they they change the overall scope of creditor rights in the country. So, for example, in this paper, they are looking at the passage of the so-called BAP CPA, which was a very important amendment to the US Bankruptcy Code in 2005. Okay? And by doing so, they were able to circumvent some of the criticism that I just talked about. They're able to hold the other parts of the institutional framework constant. Okay? Right? Again, I think I'm sort of belaboring the same point over and over again. But I think this is the most important point, which at least emerged from my review of the literature. And I mean, some of the other evidence related to specific aspects of the law. But Yankov et al. Actually, they looked at it more holistically. And this is the same set of authors, by the way, who expanded the LLSP index. They also studied the effect of enforcement. And of course, enforcement is important, right? But the takeaway from this paper was that developed nations, why do they tend to have more efficient outcomes? They also tend to have more complex insolvency resolution procedures as well. And the point that they make is that these countries, they have the infrastructure and resources that are necessary to implement these complex insolvency procedures. So simply copying complex procedures from another jurisdiction, which has a different enforcement infrastructure, different set of resources, might not really work in all instances. Okay? And then off late, more recently, people have either, at least from a research point of view, people have either looked at one jurisdiction at a time, or just very few, for example, 2 or 3, right? And then a comparative study of those jurisdictions. So, for example, this one by Davidenko and Franks is a comparison of the UK, Germany, and French bankruptcy codes. Okay? And of course, recovery rates are very different, no doubt. And this is for a very stylized, very specific sample over there. But the point that they make over here is that the UK had very strong creditor rights. And you could see that in the LLSP index as well. And of course, they had very high recoveries compared to the other two. But these strong creditor rights went hand in hand with going concern reorganizations. So in a way, the point of the study was that just because you have strong creditor rights, okay, that should not deter going concern resolutions, okay, as was shown in the UK context. Okay. And there have been several follow-up studies which have sort of tried to, get into more detail on the same theme, which is that there are these two primary sort of extremes in terms of outcomes of an insolvency system, which could be reorganizations or liquidations. And it's important to remember that these different dimensions of creditor rights, they can have distinct effects, right? So, this was a very stylized study which was conducted in the Italian context, but those of us who are empirically, who conduct empirical research, this was a very desirable opportunity for researchers, in the sense that you have, within one country, you had one set of reforms which were oriented towards reorganizations, and another set of reforms which is oriented towards liquidation. So we had the opportunity to study the contrasting effects of these reforms within a very short span of time within one country. Okay? There might be some interest in these sets of studies over here, at least in the Indian context, as we are debating sort of similar issues over here as well. Now, in Sweden, now these papers, they study the bankruptcy auction systems in Sweden. Okay, so bankruptcy, what they have was these publicly conducted cash auctions, okay, of companies that were insolvent. Those were going through this insolvency procedure there. And unlike popular perception, right, these cash auctions did not result in excessive liquidations. In fact, reorganization rates or going concern resolution rates here, they was comparable to what was observed in a very debtor in possession friendly system such as the US Bankruptcy Code Chapter 11. Okay? So they had outcomes which are quite similar to Chapter 11, but through a very different kind of a system, through an auction system. Okay? The other nuanced or interesting point over here is that a large percentage, a significant percentage of these auctions were either prepackaged or they involved a sale back to the owner managers. Now, I know that this is a topic of discussion in the Indian context as well, whether and to what extent should the promoters be involved in the insolvency resolution process. And here is one context, at least, although a smaller one, where this seems to have some positive effects in terms of preservation of going concern value. Okay? Now, going back again to the question of enforcement, it begs the question, what is enforcement and how do you determine or how do you ensure efficient enforcement? So for that, there have been a bunch of different studies on the efficiency of court systems. In particular, what these researchers have exploited are episodes when the courts in the US as well as in other countries, for example, in Brazil, I'll show you an example of China as well, where these the courts in these countries were extremely congested. Okay? So they had case overload of the type that the earlier panelists were discussing. Okay? And the message is loud and clear here, that congested courts, they don't work well. It's not rocket science, but it's good to see data on that. It's good to see sort of robust empirical evidence that case outcomes can be significantly impacted negatively when courts are congested, when they are overburdened. Okay? Now, I think one of the earlier speakers, they made a point about specialized courts, right? So obviously, Chapter 11 or the US Bankruptcy Code relies on specialized bankruptcy courts. Now, there was an experiment in China, which might be quite relevant here in this discussion. So China introduced some specialized bankruptcy courts, and the results were remarkably clear. These specialized courts, they were able to resolve cases much more quickly. Okay? And the other element of these courts, specialized courts, was that it's not just the courts dealing with only one type of case, but it's also the judges were also appropriately trained to handle those cases. Okay? So which leads me to the next point. That there is always room for discretion and in the interpretation of law. Judges, the way they rule is essentially based on their own experiences, based on their own biases, okay, which comes into play as well. And this also has been a topic for a significant amount of research in the Chapter 11 context. People have looked at the level of experience of judges and how that impacts case outcomes. The other type of research, which is sort of more recent, which has become quite popular, is that they are looking at the propensity of a judge, or the inherent bias that the judge has in favor of liquidation or reorganization, okay? Based on their previous rulings, based on their previous judgments. Okay? So overall, I think the message over here from this small set of studies is that it's not just the courts and the extent to which they are overburdened, but it's also the judges who are the ones essentially who are ruling on these cases, who are key to determining the efficiency of case outcomes, and their personal experience, their biases, that plays a huge role. Okay? I do have a few more points, if you bear with me. A lot of discussion on creditor rights focuses on rights within bankruptcy or on bankruptcy or insolvency laws. But there are laws that are equally important, if not more, outside of the bankruptcy process as well. For example, somebody mentioned these avoidance actions. Okay? But now here's an example of studies which have looked at these avoidance actions, not within the bankruptcy context, but outside of the bankruptcy context. Okay? So there are these there are these fraudulent transfer laws or fraudulent conveyance laws, which exist even outside of the bankruptcy context. So there was a rollout of the Uniform Fraudulent Transfers Act in the US, which happened in a staggered manner, again, empirically quite appealing. And that was the focus of these studies. And it sort of shows that creditor rights outside of bankruptcy are also important, but counterintuitively as well, especially the first study that I'm talking about over there, it shows that there can be unintended consequences as well. So whereas creditor rights improved, and that maybe gave rise to increased access to credit or availability of credit, but on the other hand, it strikes a certain amount of fear in the hearts of the entrepreneurs. So that resulted, it's an association study at the end of the day, even though it's a staggered shock. We need to be careful in making causal inferences over here, but there was a decline in entrepreneurial activity and business formation after the rollout of these creditor-friendly laws. Okay. There was also a point that was made earlier on about these early warning systems, right, or early warning signals. So one of the ways in which lenders have used loan contract provisions or covenants is to use them, to set them in such a way that they serve as early warning signals to them, okay? As tripwires, So, and upon breach of these covenants, then these lenders de facto have control rights, so they can influence the course of the journey of the borrower as they deem fit. Okay? And this has been a subject. Unfortunately, these contractual details are not available to researchers outside of the US. In the sense, I mean, if you're looking for non-US data on this, it's really hard to get. So all these studies invariably are conducted within the US context. But the way I think the inferences here apply equally well, because these contracts are omnipresent. They are quite so the provisions are quite omnipresent. And so the evidence that we have over here is that creditors do set these covenants in such a way that they're able to monitor the borrower effectively, and if need be, they can exercise influence, okay, or exercise de facto control rights on the borrower, and this can lead to all sorts of positive consequences in terms of governance outcomes and valuation outcomes. Okay. I mentioned in the beginning about involuntary creditors. So here's one example of how these creditors arise. And this is becoming increasingly important in the socio-political environment that we are living in currently, right? So what happens to environmental cleanup obligations, okay, upon assignment into bankruptcy? Who's on the hook for these obligations? Okay? Of course, I mean, the data requirements are such for empirical studies that, again, these studies are conducted in the US setting, but the implications or takeaways are quite general. So when creditor rights are impacted, when certain involuntary creditor rights are impacted, it has knock-on effects on the rights of other creditors. Okay? So now it's not on the slide here, but in the Canadian context, there was a very important Supreme Court ruling in 2017, which basically shifted the priorities in bankruptcy. So the environmental cleanup obligations, they, in terms of priority, they ended up priming the priority of the secured creditors as well. So these priorities have been shifted, and they are, depending upon the context, the economic context, the social context, political context, they will end up reorganizing or reordering the rights of different types of creditors. Before going on to the Indian evidence, I know Hariom has already pointed out that I'm almost out of time, but just a couple of points over here about recent developments, which might be salient at some point in the Indian context. Now, there is a lot of discussion that North America has a very debtor-friendly system. Okay? So you have a debtor in possession system over there. which is true. But some institutional developments have taken place which has sort of shifted the landscape somewhat in favor of secured creditors. How? Because of the prevalence of financing during insolvencies through these so-called DIP loans or debtor in possession loans. And most of these loans, two-thirds of these loans are provided by secured creditors, existing secured creditors. Okay? And these loans feature certain milestones which allow the secured creditors to dictate the course of the bankruptcy. Okay? So they can have very specific provisions which require asset sales by so-and-so date of so-and-so magnitude. So they can have these milestones almost as covenants within these loan contracts, which allow them to dictate the course of the restructuring. Okay? So a parallel trend that has emerged, and this is some shameless self-promotion on my part, but this is a work in progress that I have, where we are showing that there's a very sharp increase in pre-plan asset sales, okay, which is predominantly to the benefit of the secured creditors, because these asset sales, they are simply court approved. They are not voted upon by the creditors as a whole, the affected creditors. Okay? So there could be a situation where we are compromising the rights of the junior claimants in favor of the secured creditors. Similar evidence in the Canadian context as well, that institutional design might be inadvertently favoring the senior creditors. I know some of you were there at a recent conference in Chicago a couple of weeks back. And there was a lot of buzz about these so-called liability management exercises there. And these are transactions which have really attracted a lot of attention. Why? Because here we have instances where creditor rights are subverted, not by the debtor or by the government, but it's by other creditors who are interpreting loan documentation very, very aggressively. Okay? So there has been some sort of a documentation response as well, but although the competitive environment over there is such that this response has not been complete. Okay? But again, something which might enter the Indian context as well at some point, as things such as private credit develop and grow in prominence over here. Okay? Evidence from India, so as some of the speakers alluded to, the previous system was, the erstwhile BIFR system was prone to abuse. Okay? And this is shown by some research evidence in accounting, by the way, by Gopalan et al., which show evidence of downward earnings management to be able to get into insolvency. There's evidence on debt recovery tribunals as well. And by the way, these are all papers published in internationally reputed journals. For example, the first paper over there on the left-hand side, that's published in the premium economics journal, Econometrica. Okay? And so they are very well implemented from an econometric standpoint. The evidence over here is mixed. Okay? So in the immediate aftermath, there were some regressive effects of the introduction of these debt recovery tribunals, but then in the longer run, the other paper showed some positive effects. Now, going back to the earlier point that I made about the fear of liquidation, so a fairly influential study by WIG documented that, one would imagine that SARFAESI would give rise to an increased usage of secured debt, but that was not the case. Okay? In fact, this gave rise to a fear of liquidation, and that led to a lower usage of secured debt post SARFAESI. Okay? But having said that, there is also some evidence by Prasanna Tantri. I'm not sure if he's in the audience right now, but he shows evidence that the strategic defaults and the propensity to conduct strategic default, that went down. Okay? IBC, it's still early days as far as research is concerned. I know it's almost 10 years, but research takes time to develop and get published and go out. But so far, the evidence that has been accumulated seems to suggest that IBC has had positive consequences. Now, this is a dramatic shift, as you all know, from to a strictly creditor and control system. But so far, the results have been positive across a host of different outcomes, but it's still early days, and we'll see how the evidence develops going forward in the fullness of time. Okay? So I'm past my time, I think, now. So let me just end with these takeaways here. And I think undercurrent throughout the presentation has been, and throughout the earlier panel discussion as well, was that enforcement is essentially the key. You can have all the laws that you want on the books, but without proper enforcement, they do not really have much teeth, and that the overall institutional context matters. Okay? All right, so with that, do we have any time remaining for questions, or are you? Yes. Sorry? There are questions apparently.
So very interesting presentation. I loved it. So I have two questions. What is the percentage cost of enforcement in credit risk pricing?
In creditors?
In credit risk pricing. What is the percentage cost of enforcement in credit risk pricing?
Yes.
That's one.
Okay.
What is the trade-off of having fraudulent transfers within the bankruptcy law and outside?
So on the first one now, I won't be able to give you a percentage per se, but I can point you to a study that might.
I'm looking at the prevalence of models around it. Actually, are there known models around it?
So I mean, not in a systematic sense, but what I can show you is there are papers which have tried to look at this the question that you're asking using a regression-based framework. So they will typically, the way in which they will conduct these studies is by regressing some measure of creditor rights, which is essentially capturing the extent or the strength of laws on the books, and some measure of enforceability, okay, which could be through these indices that are developed by the World Bank, etc., or it could be based on surveys or interviews with practitioners on the field. So I'm trying to look at this paper, for example. They try to infer enforcement based on interviews. They gave a case study to various law practitioners, and they asked them for how easy or how difficult will it be for them to enforce on their debt, and realize on their debt. So I mean, there isn't a very clear-cut model that I'm aware of, at least, which builds enforcement per se within the loss given default framework. So typically you'll think about credit risk as probability of default times loss given default. So I think enforcement would affect directly loss given default, but it also indirectly will affect the probability of default as well, because the extent of enforcement also could drive the risk-taking incentives that the borrowers have, and the incentives of banks as well. So I think the only way in which I've seen this addressed, at least empirically, is through regression models.
So do you think it will be worthwhile to attempt and model this?
For sure. I think you could come up with an analytical model for this, I'm quite sure. And I mean, typically the way in which I understand literature, at least theory papers, when they look at the strength of creditor rights, they combine the law on the books and enforcement together. So they'll look at the composite over there, when they model creditor rights. But there could be some merit to disentangling the two as well. I agree.
And the second question. Should I repeat my second question?
Yeah, sure, please.
So I was looking for your assessment or your views on fraudulent transfers within the bankruptcy laws or outside.
Yeah. So let me actually take you back to this study that I talked about, right? Now, they squarely focus on fraudulent transfer laws outside of the bankruptcy context, because obviously you have clawback actions that are available within bankruptcy as well, both fraudulent transfers as well as preferences, right? Now, why fraudulent transfers become important in the non-bankruptcy context as well is because there are a lot of small businesses which find bankruptcy very prohibitively expensive, right? So typically they'll try to reorganize or restructure out of court. So for them, in those contexts, then having access to a regime which allows creditors to claw back on transactions that have been sort of preferentially conducted or fraudulently conducted becomes important, right? So I think it really depends upon the type of business. I particularly feel that these out of bankruptcy court possibilities are quite important for smaller businesses, I think. Yeah.
Thank you.
Thank you.
Thank you.
Any other questions?
You referred to the UK insolvency bankruptcy
Yeah.
procedures. You highlighted that the recovery rate is extremely high of 97%, some in the 90s. So is it an average rate of recovery or just a year
So
long?
this was an average rate that was observed within this specialized sample that those authors used. Okay? But the broader point is not just the percentage, right? I think it's just that it was higher than the other two systems over there. But the UK, historically, I mean, if you're familiar with the UK system, I mean, they have been quite creditor friendly, and creditor rights, secured creditor rights have been quite strong in the UK. They could actually take the company into administration, or involuntary liquidation relatively easily, right?
Thank you.
So it's based on the admitted claims, right? So whatever the admitted claim was, that would have been the recovery. But again, I don't think we should put a lot of credence on the number per se. The point was basically a rank ordering or comparison between UK, Germany, and France. Okay. But yeah, the recovery rate is basically based on the admitted claims. Okay, thank you.
Thank you, sir, for this insightful presentation. So, may I request Professor Manchi Raju, sir, to kindly present a memento to Professor Vyas as a token of our gratitude. Thank you, sir. We now move forward to the industry keynote address. It is my privilege to invite Mr. P.R. Ramesh, former chairperson, Deloitte India, to deliver the address.
Professor Sanjay Kalapur, dignitaries from IBBI, Mr. Sinha and others, distinguished researchers, fellow speakers, a lot of resolution professionals whom I know here are also present here, ladies and gentlemen. Perhaps I'm not the most appropriate person to deliver an industry talk, because now my role is different. I sit on boards and not in practice, not having been involved closely with the resolution process. So some of the points which I may make may perhaps seem outdated. But let me make some initial comments. And I stand before you with a lot of trepidation after academicians have spoken and with a lot of researchers here, and the type of questions which I asked put me in a spot of bother or worry. But the first thing we have to realize is with whatever subject matter you're dealing with in our country, we are a component of the society at large. So the positives of a society, the negatives of the society also creep into the area of what we are handling. And therefore it means that if you're dealing with the subject of Therefore, it means, let's say you're dealing with the subject of delays or the judicial system which was expressed. There is that much you can correct. Because if you really look at the judicial system today, there are 80,000 cases pending in the Supreme Court. There are maybe about 4 to 5 million cases pending in the high courts, and 55 to 60 million cases pending in lower courts, and go on to tribunals and all of it. It runs into a mammoth number. and it will take years for resolution. And so, therefore, some part of that gets into our own system. And that's why when Ms. Shah made, Anita Akhila made the point on special courts, it will definitely create a separate pipeline where perhaps you can address it, and I'll come to that. But I'll touch upon broadly three things, very broadly three things, from an industry perspective or whichever lens you may like to look at. Is first the very core of this IBC. Why is it there? You heard a lot about it. What has it achieved? What are its goals? What has it achieved? And what perhaps needs to be done? The second is, what are all those constraints which are holding up an effective resolution or effective progress in the matter? And the third, most importantly, is the future, is what needs to be done both for the present and otherwise also. And for that, I would like to take on the comment made by our chief guest, Mr. Subramaniam, where he said it is like a patient. You bring a patient to a hospital. He was bang right. You're bringing a corporate patient to a hospital. It's like bringing a person to a hospital who has debts, who owes a lot of people money. So hospital gives him some shelter so long as he's in the ICU. Those creditors won't come in. And he also has assets. So some set of people would like him to not survive so that at least they can get some portion of those assets, depending on whether he's written a will or not written a will. Leave that aside. But picturize yourself as a corporate patient coming in. Then you have two options here. The option, as rightly mentioned, the ideal option which one would like to have is the option of resolving and having it as a going concern. Then what happens is you're creating a pipeline for the future, for more debts to be cleared out, more creditors to be satisfied, and then the assets continue to get utilized and the economy continues to get benefit. The second is the liquidation. Again, our chief guest rightly mentioned, you need to have situations where you need to call it a day. You have to liquidate. That is no longer the sunrise business. That is no longer appropriate. It cannot. You're only prolonging the pain or postponing the problem. That is what I would call a need for corporate euthanasia. You should allow that, and that analysis becomes extremely critical in the initial. Now let's go back to the IBC. Yes, it was 8 years ago, October 1st, 2016. We are close to 9 years. A lot has been achieved, as you would have seen, including the move from the percentage of liquidations to percentage of resolutions, the recoveries. There are a lot of average numbers thrown up. There are a lot of average numbers of delays also mentioned in terms of delays of admission and in terms of delays of resolution. It is true, just like in a patient, you bring the patient late to the hospital, chances of survival are low. The slower you treat the patient in the hospital, the chances of survival are low. And then in this case, corporate, there is erosion in value. And that is where, beyond these averages, I would urge researchers to drill these averages and look at what are the extremes, what are the causes for those extremes. If I say the average delay is, say, 430 days, what is the longest? Because a few cases can raise the average or bring down the average, as the case may be. And that is where we need that fine research and analysis, or maybe stratification, to be able to say, these are the type of cases which may need to be dealt with differently, and we have to live with it. And I'll come to some examples as far as those are concerned. And then let's look at what are the challenges. Now, let me spend more time on challenges and on the future. The first challenge is timely admission. Absolutely right. But timely admission is linked to the signals and to an event of default. I don't think we should wait till an event of default for an admission to happen. It's just like you don't need to go to a hospital when you have a heart attack. You need to go to a hospital when you have signals of heart issue, or for that matter, any other ailment. And that is why this timely admission, or the whole host of research which needs to be done, is how many cases is the admission at the right time? How many cases the admission has actually been significantly delayed? How can we identify what is the right time for admission? Because every creditor would like to put in more oxygen, and just like anybody else, hoping that the patient will revive and therefore need not be hospitalized. We all do that at home when we deal with patients. Similarly, in corporates, good money may be poured after bad in some situations. But the fact is, the psychology of the lenders is, let me listen to the sob story of the corporate debtor in this case, and then hopefully provide him a little bit of oxygen, and hoping that that will help him revive and realize not only what I've paid earlier, but also what I've provided for subsequently. And that continues to a situation where it becomes completely hopeless, and that's when it comes to the shall I say, resolution process. Now, if we go back, when IBC was introduced, India had the twin balance sheet problem, as they call it, right? It was true that the gross NPAs were 12%, and today the gross NPAs are down to 2.8%. And net NPAs is even more lower, maybe 0.6%. But we have to realize also NPAs, or the banking system, mirrors the state of the economy. The banking system or defaults doesn't happen only because of poor quality lending. It also happens because of the state of the economy. If there are ups and downs in an economic situation, you will find situations where probability of default is higher, and therefore there will be more cases rushing into it. So we can't sit on that in a complacent position today, saying that yes, we have resolved a lot of cases, therefore it is down to 2.8%. It's equally true that our economy is doing exceedingly well and has done exceedingly well, and well, the future is, and I'll touch upon some bit on the future. The second more important, in addition to timely admission, is the swift admission process. How long do you take to admit a case? References were made in the earlier session when the chief guest and others were there, saying if everything is there, we should accept and then move on and start the process, not wait till that formal admission happens. And comparisons are made with the other processes, with alternate resolution mechanisms, which is there. But I personally feel IBC and the process which is today is a very good process. But the third most important, and here I'd like to spend some time, is the role of the various players in the ecosystem. And there are corrections which are required in this role of various players. Take the first one. The first is we talk about the committee of creditors. Now, when you talk of the committee of creditors, it's a generic term. It's a group of creditors, some cases disparate, different, heterogeneous, some cases not so. And as a result of it, what happens is each one in the group may have a different interest. And you're expecting this group to vote upon and then say, okay, 66% have voted, therefore the resolution should go through. I raise a fundamental question. We are talking about resolving the situation of an enterprise. You want to convert it to a going concern, right? That's the first objective. Then I should have a resolution mechanism which is insulated from the individual pushes and pulls of different creditors. Because a larger creditor, he may have a different interest. He's secured creditor though. Somebody who's not large may not be able to even express his interest in that situation and may be aghast in the way things are. shaping. And sometimes the delay arises because you get that unanimity or get that approval arises because of this. Should we have confidence in the resolution professional in the manner in which he conducts the resolution, runs the business in the interim period, and finds out the most appropriate solution for resolving this and recovering this? That is the greatness of the resolution professional. That's why he becomes a key individual. But if that key individual is to be, shall I say, dance to the dictates of the COC, then I'm afraid then you will have challenges in it. There are conflicts of interest. There are also challenges, which I have seen in the past, may not be there now, where even attendance of certain members of the COC in the COC were not 100%. Now, how do you get a consensus? And the third situation we had was sometimes the enormity of the problem is such that a person in the COC says, look, I am not authorized to accept this. I need time. I need to go back. So there is inconsistency between the person who's before you to deal with the situation and the authority which he has to deal with the situation. These are the dynamics within that system. As you drill this whole system of resolution, we can talk about why the delay and all of it. Then you will find that this is there. This apart from the disagreements which can happen amidst all of them. So much for the COC. And now I come to the key person, the resolution professional. When the Act came in, the code came in, and then we had this creature, the resolution professionals. Everybody and anybody who was a professional, holding a professional qualification, CA, CS, registered as an RP. And I had so many conferences I have attended of the Institute of Chartered Accountants, where they used to say, here is an opportunity. It's like that gold rush. Here is an opportunity. Go to that place with a pan, and then you will get that gold. You just need to register yourself. You are chartered accountant after all. Is a resolution professional only a chartered accountant? Is that the only skill which is required of a resolution professional? And then when you sift through that, at that time I thought the numbers were 3,000. I had one person whom I knew very well from Calcutta, 85 years old. He came to me and said, Mr. Ramesh, I am now a resolution professional, RP. Great guy, of course, I know him. He's had an industry background and he was holding a certificate of practice. He died, of course, sadly during the COVID. Then we had to deal with the situation whether you need an age limit for an RP also. Because once you open the door and say it's pure by registration, by qualification, you're CA with so many years of experience, does that make a person an RP? So I think time has come where we need to look at whether who should be an RP, how do you train an RP, how do you identify the skill sets of an RP, what sort of rating you need to give an RP, because even now when you see the list, maybe there are 1,900 or some number like that. There's a large number of people across regions registered. And then when you actually see the distribution of work, which some years ago I did see, there was concentration, of course, naturally. And then there were so many who had not even done one assignment over the years since their registration. Then shouldn't we weed out at some point in time? So that there is more focus on the right breed of people who have, and shouldn't a person rise up based on the number of assignments he does, and then that's where there is a question of evaluation. Otherwise, it doesn't mean anything. So the competence of the RP, the knowledge of the RP, the skill sets of the RP are as essential in this whole resolution process as anybody else, because he is the key person. He should be able to stand up. He should be able to hold his ground, because there will be pressures from all sides. There will be pressures from the COC. There will be threats from the promoters, the existing promoters too. And I've witnessed that sort of threats. It's not that it is not there. And then he also needs to be protected. He also needs to be protected from his actions. He genuinely does a great job, carries out his work, conducts the resolution, all approved, fine. Years later, he's called by one of the investigative agencies saying, this asset you did not detect at that point in time, you should have had this, you've done a poor job, or you deliberately looked the other way. It starts off by saying you deliberately looked the other way, and years later he has to be answerable to all of these agencies. What is the protection? It's like independent directors seek protection for their actions. I think even RPs need to be given protection from some sort of litigation against the RP itself for actions done in good faith. Equally comes the issue of compensating the RPs. The question is, are RPs adequately compensated? And this subject I don't think will ever end easily, because the RP believes that he's not compensated adequately, whereas everybody else may believe that maybe he's more than compensated. But there's another dimension questions are being asked. Should RPs be incentivized to have a variable compensation, a core and a success fee based compensation? So it incentivizes the RP to ensure that there is an appropriate resolution. Otherwise, irrespective of it, if he's going to get paid, yes, he should get paid for his efforts. But the question is, how do you incentivize him to put out his best? This is another thought, I think, which one needs to work on. Then we have the NCLT. I'm touching upon players in the ecosystem. It's absolutely true that there is a need for specialized courts. The NCLT, as Madam said, is an instrument created under the Companies Act to deal with a number of things, including the insolvency cases. So as a result, what happens is, if you go to corporates and look at it from an industry perspective, I find to do a simple merger or a demerger, it takes an extremely long time. And those simple mergers or demergers are required for me to list or take my company for listing, or portions of the company for listing, because they are different from, I have incubated them for some period of time. Now it's appropriate to list them, and therefore I need to separate them. But where do I go? Back to the NCLT. And the same NCLT is clogged with IBC. So there is a prioritization issue within NCLT. I'm sure the benches of NCLT across the country, different benches have different loads, and there may be challenges as far as that is concerned. So it's absolutely necessary that there is need for a separate bench. Though our chief guest did say you can't just throw people, you need to definitely understand the process as to why the delay is happening. But even if you understand the process, what's clearly staring at you is that if you are mixed into a group, you will not get the attention you deserve. And in this case, your own law has prescribed a timeline. And therefore, if you want to try and adhere to the timeline, you need to be able to create a separate pipeline for your case. And that, I think, is something which we need to do. And then comes the role of corporate debtors. The corporate debtors have naturally, it's absolutely the behavior has changed, what was mentioned in the inaugural session. Earlier, they were fearless. Today, they do have some fear of the respect for law, the fact that they will lose their business altogether completely, and which they have built up over the years. And if they have not run it properly, we need to address that for sure. They also, it raises that fundamental question, somebody who's failed in a business, do you still hand over the business after doing some resolution? And that's why there are issues about, and then there are some who have also conducted frauds within their business. So would you give back the business to a person whose hands are tainted? And that's why some of those issues arise. And that's why there's rightly more sympathy for MSMEs, because MSMEs are small. That's his only business. And you need to try and help and resolve that. Then there are many other stakeholders, whether it is the tax authorities, whether it's government dues and all of it. But I go back to a fundamental point. Do we need more voluntary cases? Go Air was a classic example. Do we need more of those cases, or cases only referred to through this default system or the COC system, etc. I think the numbers outside India, I have no data, I'm not in research, indicate that outside India, perhaps there's more voluntary. It's not a stigma. You can go in and then file for bankruptcy or liquidation, as the case may be, or maybe seek a resolution, as the case may be. In India, unfortunately, it is somewhat seemed as a taint, but that is perhaps another thing. But while doing that, one of the things which bothers industry, and it also bothers industry in different sense, take the example of airlines. When airline companies went belly up and they are into this process, what did you find? You found very valuable planes lying parked in the airports with all their engines covered. Isn't that a wastage of economic assets? The same airlines, other airlines in India have placed orders for planes which are going to take 5 years to come. We are struggling with capacity because lesser rights are not necessarily recognized in the same manner. Shouldn't we find solutions to use of the assets pending this? And in this case, leased assets. And I'm giving you an example of aircrafts. I know you can throw a lot of laws, you can throw a lot of reasons, but it saddens me when I've seen, even now I see Jet Airways aircrafts parked, or Go Air aircrafts parked. You go to airports and in the remotest corner, it's decaying. And that's exactly the point which is made. More the delay, the more the erosion and value add. But here is that very asset is useful for somebody. We are desperate as a nation. But that is not allowed to be released. And then there are a whole host of conditions. Even, not forget, even if our nation is not able to use the asset, there are others who need to use the asset. Then another issue which is a big constraint. Fundamentally, we are talking about resolving an enterprise which has liabilities, which owes to its creditors, and which has assets. Then there was some mention about how do you evaluate performance of an RP, or the process itself is whether the value of the assets, recovery is one barometer which was mentioned. But the fundamental question is, if you look at all of these assets, you will find the quality of financial statements is a huge constraint in bringing about any resolution. Because 4 things are happening. There are assets recorded in financial statements with erroneous values. They're of no use. That value in the financial statements is of no use for a resolution. Second, there are assets not recorded in the financial statements. Could be, and within that, of course, intangible assets, where the standard itself does not allow you to recognize certain intangible assets. Then you have liabilities which are recorded at lower values than they should be in the financial statements. And there are a lot of liabilities outside the financial statements. Suddenly, when an enterprise is before this whole process, a resolution professional is faced with what are the assets? What is the value of the assets? What are the liabilities? Suddenly it discovers there are far more liabilities than what's in the books. There are many more people who queue up. And that delays the process in terms of validating the assets and validating the liabilities. So the quality of financial reporting in our country needs to go up significantly if we have to speed up the process. And the final dimension of this is fraud and diversion of funds and assets. Now, there is a huge fraud. You know there is a fraud. This entity is in this state of affairs because funds have been diverted and it's been starved of funds, stripped of assets, etc. Now, how do you just go about resolution and distribute whatever assets is there to whatever the creditors? Or you go after and start going back and bringing back those assets which have been diverted and give back? This was also alluded to by Dushyant. You can have 2 ways, perhaps. One is to do the first step, and the second is don't stop the going after and get back those and start distributing those back in some equitable manner. Back again, it takes a long process. Don't hold back the process. But the real challenges is in entities which come before this process, which are fraudulent, and therefore they are in that situation. And that's why when I come to this third part, which I said, is the causes of corporate insolvency. Why do companies come before to this stage? First, they can come because of an economic reason. Genuinely, certain businesses go out of business. Today, do you have carbon paper? No. So if you're a business manufacturing carbon paper, you will not be, nobody needs you today. I'm giving just simple examples, but it can dramatically change as we talk about the future. The second is it could go bad because business strategy and conduct or pure hubris. I would like to grow and grow faster and acquire more M&As, etc. Hubris, and suddenly you go bust. We even had one of the educational companies going bust because of the fact that during COVID, that was in great demand. Online education was in great demand. So you go on acquiring and then build something, not realizing that after COVID, then the demand for online education dramatically dropped. And then you needed to address, by then you're perhaps too deeply leveraged to where it is. Businesses can go bad because of policies. It can be, suddenly you can declare a particular state as a dry state, all the breweries in that state go bankrupt, will go bankrupt. Naturally, that's a licensing issue, nothing wrong in that. It can also go bad depending on how you're exposed to. Sometimes a lot of exposure to state and government debts does pose challenges because of uncertainty of that liquidity. Because every case in infrastructure, a lot of cases in infrastructure go for arbitration. Until the arbitrator decides, your debts are not released. And you have no visibility as to when it will happen. And there's stress in the system. So these are some of the common things which perhaps we need. There are other players who need to work on it, but they definitely need to work on it. Fourth reason, which I've already mentioned, is fraud and diversion. Fifth, which we need to be mindful of, particularly now for the future, is the impact of technology. The developments with technology will drive some businesses to closure. And these are the signals we need to look at and prepare for it. I think this business will close because of technology. Look at many intermediaries. Where is the travel agent today? He has disappeared as a business. You used to have fancy offices in those days because through an app you're able to do. There's so many intermediaries. And that's the principle of disintermediation which we talk about, which will eliminate businesses. If you are in the business of filing tax returns today, perhaps you may not. It's become so automated in a way. I'm just giving stark examples, but I'm saying technology, the fourth industrial revolution, and I'm not even talking about artificial intelligence and its impact on businesses. We need to have that to do that. And the impact of competition and consolidation. The chief guest spoke about duopoly, but that's a reality. So somebody who's in that industry either has to consolidate or has to exit because it can't survive too long. Airline industry needs scale. With 5 planes, 10 planes, you cannot fly. You will need 400, 500 planes easily. And none of those airlines we have of that size, barring maybe closer to 2 in India. Global airlines are even much more larger. So somebody who wants to start an airline business says, I have 5 planes. And it's a cash guzzler, just like telecom business today. If for 5G changes to 6G, then unless you have financial muscle, you'll be wiped out if you're a small player. And this brings me to this whole issue when we talk of collaterals and the assets and all that which was spoken about. Dushyant spoke about intangible assets. Intangible assets are great. They do have a value so long as the business is running. The day the business is stressed, the intangible asset erosion value happens faster than tangible asset. There are banks which have lent against telecom licenses. There are banks which have lent against valuation of airline brands and saying this is the brand value. But if the airline is grounded, there is no value. Who's going to buy that brand? Who's going to buy that telecom license? If you have no subscribers, there's no value. So we have to be mindful of what is the collateral and what is the value, and this is what the RP faces. So let me come to the last stage, which is the future. I'd give 10 recommendations broadly. The first is we need to have an equal emphasis on prevention as opposed to resolution. How do we ensure that cases don't come up? How do you prevent? Which is part of that early warning signals, which was spoken about, and I'll touch upon that a little more also. Second, which I emphasize, there is need for corporate euthanasia, and we need to try and encourage that too. Nothing wrong in that, even if it may distort some of the statistics of your liquidation and your recovery process, etc. But the third important thing, which is what banks particularly should have been doing, is continuous monitoring and calibration. The banker sees what's happening. Everything goes through the banking system. He is the committee of creditors. Don't tell me the diversions are not known to the banks when large sums are diverted. The same check, the same fund transfer goes. Today, if I pay out from my bank account as an individual to somebody, I get a call from a bank. Sir, you have paid that, what for is it? He's worried about fraud, of course, maybe. But the fact is, there is surveillance. He is monitoring. So why can't bankers, and this is a question for the banking system, not for IBBI, they have to have, and every time I find, even when the time I used to do audits, company shows a certain value in the books as a loan to the bank has a completely different value. How can you have that? Then if it goes into this process, you need to have what is the right liability, correct? And then this challenge about bankers themselves encouraging certain structuring so that they don't want it to get into a default situation. But it's not about avoiding default. It's about ensuring resolution of the issue. It's not that saying, why don't you, we will lend to this entity, that in turn will lend to you, and then you repay me back. So whatever is the evergreening or terms which are used, there are many terms which come up. So the fourth is, in my view, law is the end state, of course. There is need to focus on businesses, their challenges and their pains. We need to understand the pains of businesses. What for? Why is this happening? And sometimes businesses are exposed to certain structures. I'll give you a classic example that happened in Delhi. You have the Delhi-Gurgaon Expressway, right? A few years ago, suddenly there was so much rush at a particular toll that the government decided you remove that whole toll and throw it away and put it closer to Manesar or water. Now, what happens to that? The business model was based on a toll, and the funding was obtained from banks to fund that service, that concession arrangement. And lo and behold, because of certain public interests, sure, this happens. Now, shouldn't we then also provide for a mechanism to alleviate this sort of a thing? And the fifth, we talked about separate insolvency courts. Sixth, encourage voluntary resolution liquidity. I spoke. Frauds and diversions, in my view, are the cancer which is eating into our economy. We must have mechanisms to detect frauds. If you touch upon the subject of frauds, globally, companies lose 5% for frauds of their top line, not of the bottom line. 5% of, and most frauds are only detected by tips. 43% of the frauds are detected by some whistleblower or because of some whistleblower. 14% because of internal audit, management review something 13%, and a large part of the frauds. If you see the cost of frauds globally, employee frauds, median is 8 or whatever it is loss is $80,000. Owner or executive fraud is $500,000. So it is management fraud which one needs to really worry about. And surveys have shown, whether you take the PwC survey or a Deloitte survey, that there will be more and more frauds, particularly because of the cyberspace and the developments in technology which will impact businesses. And we need to have mechanisms to detect these frauds early enough. There's a huge plethora of data which is available, information which is available. If tax department can use information and perfect its 26 AS or AIS annual information statement, its own surveillance, and you get, why can't we use data to be able to detect potential frauds? And that was perhaps one of the last things which I'll come about. Then we need to create a powerful, trained, and competent cadre of RPs. It's not having a list of RPs. It is competent cadre of RPs who can rate. You can say, this is just like maybe, as there has been objection to it, of course, as to where in the advocates you have a senior counsel, you have advocate on record, etc. Do we need to reach a stage where you need to have a senior RP or somebody who's recognized because of his caliber or his experience in handling RP cases distinct from somebody else? Or maybe an evaluation of the RPs. I no specific suggestions in this, but just a thought saying all can't be equal in this. 9, there's a need for business surveillance unit. You know, like in United States, you have this Center for Disease Control, whatever it is, which comes up, surveys, and then comes up with vaccines, etc. In India, I believe there is a need for a body which continuously surveys businesses. Surveillance is required to say, here are these businesses which for economic reasons may go down. Here are these businesses where there's something shady which is happening. We need to step in quick. Here is a business which can go bust and may get into the beer. Just somebody who's independent of a self-interest which a bank may have or anybody else may have, who's surveying this. There's enough of data. Everybody files financial statements. There's so much of information which is happening. The GST portal has tons of information. Income tax portal has tons of information. Every financial transaction goes through that. And with the great analytical tools and artificial intelligence today, it is possible perhaps to develop these things. And finally, for you, ladies and gentlemen, research of the causes, the effects, and the impact of outcomes, particularly of legislative and other actions, we need to know. So that we need to know, is this action which we have, legislative change or the initiative which is introduced, has it produced the desired result? What is that impact? The more that feedback which comes from research, it helps the entire insolvency and bankruptcy ecosystem to flourish and meet its objectives. Thank you very much for your patient hearing.
We can have about 3 questions.
You're encouraging or creating a level playing field?
Hello, sir.
Yes, please.
For RPs, age limit should not be considered, sir, because some people are dying at 35 years itself. Some people are living above 80 years and they are able to handle the organization properly. So we need more experienced people. If you stop by keeping some 60 years, more experienced people we will lose.
I know, sir, but
So-
I'm telling you where I'm coming from. I myself, I'm 70 years old.
Oh,
If
yes.
you personally ask me, am I looking as a patient of Alzheimer's?
No.
Perhaps no. Perhaps no, I don't even know. But
Yes.
then we also have a US presidential candidate who was felt not fit for the job, for whatever it is. And then there was clamor on age, etc. I agree, age is a number.
Yes, sir. Because
But after a certain threshold, we need evaluation. That is important. Companies Act says after 75, please go to the shareholders for a special resolution each time you're appointing. They have not barred a person from being a director over the age. I'm saying maybe, but the fact is, wouldn't you want somebody who has the energy to resolve? It's not just experience, it is the energy. The RP's work is a very tough job. The bigger the case, the tougher it is. That is the only point I mean. I threw up a question, not necessarily. Can he run like a youngster, is the question. Correct.
by sitting also they can manage, sir. Today, technology developed.
Okay.
So you should not support age limits, sir. What
Yes, sir. Yeah, I know. I know. From IP, we moved to IPE so that you create strength. No, within the IPE also there is a person, right? Who is working on it.
You have expertise. You can have any number of people with expertise inducted in IPE and run the process like we do in our IPE. There's no bar.
Correct.
Yes, sir.
System permits both individuals as well as entities. There is nothing wrong in taking a measure whether an individual is perfect.
Anyway, you stirred a hornet's nest. It's okay.
From our side, we should not support, sir, such type of things.
I raised a question. I didn't give an answer. I didn't say we must.
So,
Thank you.
Yep.
So, is there a mechanism on or a framework on identification of defaulters? Is it because of the see, diversion is one thing. You know, if someone defaults because of the external situation or the social situation, still that is also has been considered as a default. But any classification or any framework on those lines?
The default can arise because of an economic reason, as I already said. And default need not necessarily be a stigma. And defaults can be temporary and need not be permanent. But default is definitely, without doubt, a signal, and which needs far more analysis. And who better than the banker to know when there is a default? That is different from diversion of funds, etc., where default is not there. We had the classic case even the other day in the National Financial Reporting Authority conference, it was quoted, of Coffee Day, where thousands of crores were received, were lent out, diverted. Last day of the year, the money came back by way of a check. The first day of the next year, it went out again. And then finally, the entity went bust. So was there a default? The answer is no. The money was received by the year end. The auditor also said the money came back, so what do I do? But then the next day morning, it went out again. So then you have to look at what is it, and that is where we can't generalize, but that's why I said economic reasons and fraudulent reasons need to be distinguished. And we can't look the other way for a fraud. We need to act. Yes?
Sir, there is a concept of look-back period for CRP.
There's a concept of?
Look-back period.
Yeah.
So one of the senior banker was suggesting where the look-back period is from the date of NPA. Where the account becomes NPA.
For what purpose? I'm not an expert on this, but for what purpose? A look back to see if there is a diversion can be any period. It need not go back to the date of default.
No, in that
default is the last day.
Correct. But in the CRP process, when the case is admitted, the RP has to look back the period of 2 years from the date of admission of the case. But the thing is, the NPA was long back. Maybe the NPA must be in 2020 or...
In my view, if the RPA has enough signals that there has been diversion of assets earlier, then that needs to be definitely...
Of course.
That is the point. Ultimately, all of these are indicators for you to decide. It can't be a rule to say this is what it is. I don't need to look beyond that at all. But if it's staring at you, you need to definitely look.
So,
the lady who has a question up, can we give her a chance? Give her. And then I'll come back to you, sir, provided time permits.
Hi, sir. I'm Priyadarshini. I'm doing my LLM and Insolvency and Bankruptcy laws from Nalsar University. I have nothing towards the age factor which you said for RP. I'm neither supporting it, neither objecting it. But don't you feel when you inculcate youngsters, there's a new perspective. There's a fresh thought to it. In the sense, now that IBBI has recently agreed for the 2-year LLM. Once after the 2-year LLM, we write
True,
an
ma'am, but if your question is on age and the implications of whether there should be a ceiling on age or a floor on age, I think that's a closed discussion for the time being, but there could be multiple views on it. And that's not yet, it's not appropriate for me to say what is the right thing. But each one has an interest of his own or her own, and let's leave it at that.
Sure.
Okay.
Thank you. Thank you, sir.
Last.
Let's say today, the moment defaults or NPA, they're taking into IBC or SARFASI, rather than looking into the facts or the root cause analysis, why or where, how it went wrong. So if we have a framework or something in place pre-admission, where it has to go through on what this has happened or what is the root cause for it, do you think that will help revive the business?
The root cause analysis in any case has to be done. You can't, it's not bereft of root cause. You can't do a resolution without even a root cause analysis.
But that's not.
How do you do a resolution?
But that's not been done in most of the cases. No,
Well,
so
then it is for the RP and the COCs, that system, to decide. But I wouldn't be able to resolve something without knowing why we are here in the first instance. Why are we where we are? What is it that will make me go to where I want to be? And only when I know why reason for where we are, then I won't be able to decide on the future.
That's not happening in at least the most of the cases. So.
I'm not competent to answer that.
Thank you, sir.
Sir, one question. I'm Navneet Chaudhary representing AIF. The challenge which we are facing as an investor is the due diligence. It takes not only a lot of time, but we find at occasions that there are no details available, no documents available. Forget about the CD, that is the past. Even I'm facing a challenge with respect to the RPs not filing the tax returns, statutory returns on a timely basis during the CRB process. So eventually we buy a company, we get a company with all the backlogs and everything. How to deal this issue, sir?
Questions, do you need that company then? Why do you need to take on the headache if you are aware of all the issues? That's a different challenge. I concede that. That is an issue, challenge of the RP, how it's dealt with, and the core within the company itself, what backlog themselves have. But you can't take it on and then say, I found out this is all it is. So don't take it on. Yeah. There you are. Yeah. Correct. Thank you. Thank you very much.
Thank you, sir.
What we are conducting the exam is PGIP, post-graduate insolvency program. Anything LLM is issue has been flagged with the regulator. It is between the university and the concerned regulator. We are restricted to only PGIP, so please keep in mind, if some university or some institute is telling you that I have a LLM course approved by IBBI, that is factually incorrect. Our course is PGIP course, that is a 2 years postgraduate in insolvency. Thank you. No, that is not correct. We have clarified that because you see the credit point. You have to do additional credit point, and that degree has to be given by LLM in consultation with UGC. We have no role in this LLM. There was some confusion we have clarified. IIC has also flagged this. So as a young student, all of you should be understood. There is no course called LLM in insolvency which is approved by IBBI.
Thank you, sir, for the clarification. I request Professor Hari Om to please present a memento to our distinguished speaker. Ladies and gentlemen, please note that we will be having 2 parallel sessions on research paper presentations in room AC7 on the 2nd floor. I request you all to join us for lunch at the atrium and reassemble at room AC7 latest by 2:30 p.m. Thank you.